All right. Again, my apologies that you all have been waiting as long as you have. I knew I was going to be a little bit late, and Ms. Nelson hopefully shared that with you, but it was longer. We have a final plea calendar this morning, an inquiry calendar, and then we have Mr. Cotton's plea as well. And then Deputy Gordon tells me that the folks from the 1 o'clock are already up. So if we've got time, we could make a dent in the 1 o'clock, which will actually become probably a 1:30 start time for what we don't get to. I know we were going to start with Mr. Cotton's plea, but we have a whole bunch of people who are likely here for what I'm going to call shorthand the Israel Bird case. And so I thought we would figure out what we're doing in terms of final plea in that case. Is Mr. Abadi here?
Deputy Oakham is Robert's prisoner.
Okay. Good morning, Ms. Oakham. How are you?
I have a cold. That's why I'm not in person, Your Honor. I'm going to do it by Zoom just to keep everybody safe.
Well, we appreciate that. We don't want hantavirus or your cold. So we're going to keep you there. Have you been coordinating with Mr. Abadi as to where the state is with the defendants in this case?
Yes, Your Honor. My understanding is that all discovery has been provided as well, and then it's just offers, but they're murders. So the standard offer for the state for any murder case is life, Your Honor.
Well, but not everyone faces murder allegations. This is why I was hoping Mr. Abadi would be plugged in, or maybe you know how that's flowing. But there are it's a big case with many defendants, and there are defendants who are not implicated in the indictment with either of the two murders in the indictment.
Yes, Your Honor, that would be Mr. Blackwell and Mr. Miles Pratt.
Okay. I guess we'll go through this methodically. Mr. Mitchell?
Yes, Your Honor. Good morning.
Good morning, sir. Is Mr. Blackwell here? He's in custody. Okay, I don't have, this calendar doesn't, oh, it does show. I can know that. You don't need to bring him out yet. Let me figure out what we're doing with these many cases, and then maybe we can get people on their way. Have you, Mr. Mitchell, had a chance to speak with Mr. Blackwell about whatever offer the state has made you?
I've spoken, but I haven't received an offer.
You haven't received an offer. So let's pause. Ms. Oakham, what is the point of final plea is for me to learn from the defense attorneys what they and their clients think about the offer from the state. And here we are with one of the two defendants who doesn't even have a murder charge. And Mr. Mitchell is saying, I don't know what the offer is. I can't talk to Mr. Blackwell about that. Have you or has Mr. Abate communicated an offer to Mr. Blackwell?
If I would take Mr. Mitchell's word on it, that an offer has not been communicated, Your Honor, and I will communicate an offer to him.
Okay, that makes final plea kind of difficult to get through. So it may be that what we have to do today is limit this to confirmation that everyone has discovery and figure out when we can get everyone together again. That's frustrating. Okay. Mr. Mitchell, how are you doing with discovery? As I understand it, everyone had to submit a hard drive, and then a very industrious paralegal in the DA's office filled those hard drives with discovery and got them back. And I pressed the lawyers to make sure they were doing this because it really was on the defense to get those hard drives to the state, and then they were taking care of business. You are one of the two where I don't have an answer that you got a hard drive in there and got discovery.
I did get a hard drive in there. We do have discovery.
Great.
There may be some things I need to talk offline with the state about how to access certain things.
Okay.
But I get the gist of it. I think I'm on the right track.
Okay. You're not feeling like you have been undersupplied with discovery?
No.
No issues there. You didn't file any motions on behalf of Mr. Blackwell, so I'm assuming really this is just, are you working it out or are you going to trial?
Right.
But you need an offer in order to figure that out.
That's true.
Okay. Would you like Mr. Blackwell to come out so I can let him know what's going on? I'm happy to engage with him.
Sure.
Okay. Can we bring Mr. Blackwell? You can just come to the door. Ms. Cabrera, while we're waiting on that so we can be efficient, you have had a hard drive for a while. You're good with discovery.
Yes,
Okay. Mr. Byrd is pretty squarely charged with almost everything in the indictment. So I guess what your offer is.
Yes.
Okay.
So I don't think anybody has a formal, I don't think anything was filed. I don't think anybody has a formal offer, but we all have an idea.
Okay. I don't require the state to formally file offers. I require them to communicate the offer. And it sounds like that didn't happen. But let me turn to Mr. Blackwell. Hey, good morning, Mr. Blackwell. I'm Judge McBurney. If we met, it was a long time ago in your case. And today I'm checking in with your lawyer to make sure he's got all the discovery in the case. And really what we were going to talk about was whether you and your lawyer were interested in resolving the case based on the offer the state had made. But you don't have an offer yet, so we can't have that conversation. I'm going to figure out another day real soon when we can get you back here and we can have that conversation. Your set of charges in the indictment are ones where it might well be what we call workoutable, because you're not charged with some of the more serious offenses in the case. So we're going to get you back here soon to have that conversation. Mr. Mitchell tells me he's got all the discovery. You might not have seen it because it came on a hard drive. It's zillions of documents because there's so many defendants and so many charges in the indictment. You're just in a little sliver of that. And I know Mr. Mitchell's trying to stay focused on what in the discovery relates to your charges. But we, the system, owe you a date in court where you can say, I understand what the state's offer is. I don't want it, or I do want it, or I'm going to go non-negotiated. And we'll need to figure out someday soon when we can do that. Okay? Soon as in a few weeks, not months and months. All right? Any questions about any of that? Mr. Mitchell, anything else we can do today in connection with Mr. Blackwell's case?
No, Your Honor.
Okay.
I just want to speak with him.
Got it. We'll keep him up. And if they can have you back there while I'm having these conversations, great. Otherwise, I want to at least get through the co-defendants because I think we can get a lot of folks on their way once we've done that. Okay? Thank you. All right. So, Ms. Cabrera, you were up next and we had already started the dialogue. You've got discovery. Do you want me to bring Mr. Byrd out just for the let's have contact, or how do you want that to work? Okay. All right. So if we could bring Mr. Byrd to the door.
While we're waiting for him, I'm also on your 1 o'clock calendar.
Okay.
Mr. Fagan and covering for mistakes for Mr. Fagan on that calendar, but he is appearing virtually from the state system. Is it possible for me to appear virtually at 1 o'clock as well?
So it'll be 1:30.
It's 1:30?
Yeah. I mean, it was 1 o'clock, but we're moving it to 1:30. What are we doing today with Mr. Fagan? Is it working out?
We don't know. He's in the state system.
Oh, so you want to have a breakout with him?
He has
Okay.
an offer that might resolve it.
Okay. I'm fine with that since he's going to be virtual. If you could join us at 1:30, and we can put you guys in a breakout room, we'll do that.
Okay.
All right?
In the meantime, I'll just be in there.
Okay.
Peace out.
All right. Mr. Byrd. Hey, Judge McBurney. I think we can do your final plea hearing today, unless you need to talk to Mr. Byrd first.
No, it doesn't.
He's in line with what's going on. Mr. Byrd, Ms. Cabrera confirmed with me just a little while ago that she's got all the discovery in the case. It's on a big hard drive. She is working through that, and things that are physically shareable with you, if you want them, she can get to you, paperwork, but videos and audio and whatnot, that requires she got to bring a laptop into the jail. You are charged with most of what's in the indictment to include murders. And so final plea, which is a conversation about, is this a case that's going to work out right now with the plea, is a little different. I'm assuming you're not interested in pleading to life right at this juncture. Okay, I understand that. We're going to move your case towards trial. We need to figure out who's going to be tried together. There are too many defendants to try everyone at once, but your lawyer and the prosecutor and I have begun talking about how there are some groupings because there were 2 different murders and there might be a trial of one murder and then a trial of another. But the state really gets to take the lead on that, saying, hey, Judge, these are the defendants we want to try first. And we'll maybe do 4 or 5 at the most in one group. And we'll see if we can get that set down sometime soon. Okay? You got any questions about anything? All right, Ms. Cabrera will be seeing you soon, and she'll keep talking with the prosecution about whether there's something to do with the case other than trial. All right? All right, be safe. Ms. Ocom, the calendar says Ms. Hicks on all these positions. I don't know that I know Ms. Hicks. Can you tell me who that is?
Yes, Your Honor, she's the gang AD assigned to your courtroom. She's out this week, so I'm covering, but either way, we will both be here for the trial, so
Got
it's
it. Okay, thanks for just connecting me with that name. All right. Next on the calendar is Mr. Shamblas. I don't know if Mr. Francis was able to be here today.
Yes, Judge.
He's on Zoom. He is here. Excellent. Mr. Francis, let's get you on the screen. Good morning, sir.
Hey, Judge, how are you?
I am well. Yourself?
I'm fine, Judge. I heard well, we'll talk about that later, about your future.
Oh, yeah, my future. Yeah. So I appreciate the well wishes.
Judge,
But you and Mr. Shamblas, I have you down as having discovery. You were new to the case in the sense that I believe it was Ms. Gordon had to roll off for the defense and you took over. Did you inherit the hard drive from her or did your team just send in a whole new hard drive?
no, I think we inherited then, but I can say this, Judge, I have not met you, Mr. Shamblas, yet. I've had some life challenges that have gone on ever since I had to get in that case. So I'm just getting back up to speed. I will go see him this weekend, but we're fine as far as discovery. I just need an offer and I'll start that process. And I think it's, from what I'm hearing, I think it's a matter we can get resolved.
Okay. Well, why don't we bring Mr. Shamblas up to a screen? So he's never even seen you. He can at least lay eyes on you. Let's do that. I think that's an important connection to make. Thanks.
Right.
And Mr. Hoover, you are up next with Mr. Clark. Good. Appreciate you being here for whatever we're doing today with this case. Hey, Mr. Shamblas, if you come right up to that microphone there. Great. I want to introduce you to Mr. Francis. See the gentleman on the screen?
Sir.
He's your lawyer now. I'm going to call him your new lawyer. You can see from his beard, he's not new to being a lawyer. He's been a lawyer for a long time, but he's new to your case. You were working with Ms. Gordon, and she had to come off the case because of a conflict, not with you, but because of connections she had to other people in the case. And so Mr. Francis has assumed that role. He's got the discovery in the case, and he has been working through some other things going on. And he told me that he's going to come visit you this weekend to start making that connection, talking with you about what's up and where this case might go. Is it something that could resolve? Is it something that needs to go to trial? And I'm here for either thing. If it's going to be a plea, let's do it. If it's going to be a trial, the state needs to figure out, because there's so many defendants in this case, which are the few defendants that they want to go to trial with first. Okay?
Yes, sir.
Mr. Francis, anything you want to add?
No, that's it, Judge. Thank you so much.
Okay, so he will see you this weekend. You guys will begin talking about the case, and then Mr. Francis will let me know how quickly can we get you back in court if it's a case, something that's working out. And otherwise, I'll keep pressing the state, the sort of last checkpoint before I say to state, all right, it's time. Let's go to trial. Who is going to go to trial first? So you should see some movement. I know you've just been sitting there, but you should see some movement soon. Most importantly, your lawyer, who's going to be with you for the rest of the case, will come see you this weekend. All right?
Sir.
All right. Thank you.
Well,
All right. Mr. Hoover, with Mr. Clark, I know you've got discovery. You were one of the defense attorneys who filed some motions that we've litigated and worked on. And hold on one second. Mr. Francis, if you don't have any other cases on these calendars, you're good to go. Did you have anything else?
No, that's all I have, Judge. Thank you. Have a good weekend.
All right.
All right. Bye-bye.
Appreciate it. Take care. Are we, other than double confirming you've got discovery, it's where's my offer and we're ready to go?
yes, Your Honor. Also, just a little backdrop. So March 13th, we had the motions hearing. Based off of that hearing, since Statements were made.
should we just bring Mr. Clark out, have him stand next to you?
Sure.
Okay. Thanks. Hey, Mr. Clark, just stand next to Mr. Hoover, please.
So March 13th, we had a motions hearing with Mr. Batse. A lot was done then, but we did determine during that hearing that because of the amount of clients that are defendants that are involved and the dates that it's going to be separated. On top of that, so there will be more motions once we determine who's being tried when and who's taking pleas. So they're going to be more later on because there is there is a Bruton issue.
Okay.
Because of Mr. Byrd and a couple others that we will have to address once we know what's going to happen. On the 9th of last month, we had a bond hearing, which you denied. However, you did say that we could readdress it today once we had more information. And whenever the court's ready, we are ready to go forward with the bond hearing. So we have the bond hearing today. We will have more motions at some point when we know what's happening with the rest of the co-defendants today.
But well, I don't know that we're going to learn today what's happening with all the co-defendants. It doesn't sound like the state's in a position to do any of that. No offers were sent out, and we all knew for many of the defendants, the offer would be you can plead to life, and that tends not to result in pleas on final plea date.
Right.
Really what I see coming next is, all right, here's a trial date. State who are the 4, max 5 defendants that you want to move forward with first. And as we've discussed, there's some natural breakpoints. One murder, and there are a number of defendants who are charged with counts 1 through 10. Your client's one of them. And so that was one potential breakpoint. And we did talk about there might need to be a defendant who, even though he is in that universe of counts, couldn't be tried with everyone else because of the Bruton issue.
Yes.
And so, yes, there'd be a motion, or it would be, that's not a grouping that would work, which is really saying the same thing. Whether we have to litigate the motion or the state acknowledges, you're right, we need to work that case out or not include that person in there. We'll see. But there's, when you say more motions, it's not, oh, and by the way, I want to suppress this phone, I've learned more. It's more structural motions, as in the trial can't have these people together.
Correct. Yes, sir.
All right. And you believe there is a sufficiently substantial change in circumstances that it merits having another discussion about bond with Mr. Clark?
Yes.
Okay.
Based off of the last hearing we had. Yes.
Okay. All right. Mr. Clark, I'm going to be bringing you back out here later this morning to do that, okay? Do you have any questions about anything we discussed?
Are you on?
All right. Thank you. Ms. King?
Good morning, Your Honor.
Hey, how are you?
Good.
Are you ready for me to bring Mr. Few out?
Correct.
Okay.
I do have discovery, and I would agree with Mr. Hoover that there may be a possible grouping issue, but it may be moved depending on how they group the defendants together.
Okay.
And I did relay the offer to Mr. Few this morning.
Oh, all right. So you guys have had a chance to talk about it. And I got my wires crossed. You're actually the new Rachel Gordon. I don't remember who was working with Mr. Shamblas. I just knew that Mr. Francis got on board, but Ms. Gordon was working with Mr. Few, and now you are.
Yes, and I picked up the terabyte drive.
Great. Can we bring Mr. Few? I'm assuming Mr. Few is saying no thank you to what the offer is?
Yes, Your Honor.
Okay. Good morning, Mr. Few.
Good morning.
Mr. Few, I was just chatting with your lawyer, Ms. King. She confirmed that she's got all discovery in your case, which is a lot of material. And she also told me that she received an offer from the state. If this was a case you wanted to resolve today by way of entering a plea, I just need to make sure we get on the record what that offer was. What was it that you received, Ms. King?
Life.
Okay, it's pleading to one of the murders. And Ms. King relayed to me that you weren't particularly enthusiastic about that offer. Is that correct?
No, sir.
You'd rather go to trial.
I don't know yet.
You don't really want to go to trial either. I hear you. So here's where we are today. I'm just making sure the state's delivered an offer. They've provided all the discovery so that I can now set this down for a trial date. And then that's going to be the ultimate deciding point is when it's trial time, Ms. King is going to continue to press the state maybe for a different offer. There may be reasons you can give her to seek a different offer. But ultimately, if the offer remains something you're not interested in, then we'll be at that crossroads where it'll be, okay, then we need to have a trial. If a jury says not guilty, no matter what the offer is, you are done with this. If the jury says guilty, then we just move on to sentencing. But we're not quite at that crossroads. I need to make sure everyone has discovery and what the state's offer is at this juncture. You need to understand that the offer in the future may not be the same. Because of when these crimes occurred, they could later on say life without parole. Today they're saying life with parole. And as long as you understand that the offer could get better, but the offer could be less favorable in the future, then I know you've had a chance to think about it. And as of today, you're not prepared to work the case out with those kind of parameters. Is that correct?
Yes, sir.
Okay. Any questions for me?
No, sir.
All right, Ms. King, anything else on behalf of Mr. Few?
No, Your Honor.
Okay, thank you for jumping into this case. I appreciate it.
Thank you.
All right,
And for position 6, I'm subbing for Mr. Luemba.
all right,
Yeah.
great. Thank you for doing that. He was the only one, now that I know Mr. Mitchell got his hard drive, where I hadn't gotten confirmation about hard drive and discovery.
Mr. Luemba told me he has the discovery.
Great, thank you. Is Ms. Jones up?
Yeah.
Okay, can we bring her out, please? And Mr. Regis, you are next.
Thank you, Your Honor.
It looks like we're talking bond today also. Is that, okay?
Allow such.
Yep. Good morning, Ms. Jones.
Good morning.
Your lawyer, Mr. Luemba, couldn't be here today, but Ms. King, who is a lawyer for a co-defendant, not your lawyer for the long term, is just standing in today, so you have a counselor by your side. Today, all I'm doing is making sure everyone has discovery, whatever the state says the evidence is in this case. And Ms. King has shared with me that Mr. Luemba does have that discovery. It's in the form of a big hard drive. And he's figuring out, are there things he can actually leave with you, so paper, or are there things that you guys would need to look at together on a laptop or something like that? Ms. King, did you get from either the state or Mr. Luemba an offer that you and Ms. Jones had a chance to talk about?
I relayed, based on the standard practice, that it would be a life offer. I relayed that to Ms. Jones this morning.
Okay, but it's nothing that Mr. Luemba talked to you about?
No.
In other words, he didn't say, oh, no, the offer I got is X.
No, Your Honor.
Okay. Let me look up one thing. Ms. Jones has sort of a unique collection of charges in this case compared to a lot of folks. I'm just trying to see where she fits in. Okay, yes, that would be the offer. I didn't know what count the second murder was, but that's one of Ms. Jones's counts. So Ms. Jones, and did you and Ms. Jones discuss that at all, or because you're not her lawyer, you really didn't engage?
Substantive discussions, I just explained to her the offer would be life.
Right. Ms. Jones, I'm assuming, but you should correct me if I'm wrong, that you're not particularly motivated by an offer of life in prison at this
No,
point.
sir, I'm not.
Okay, I get that. My goal then is to get you into court for trial as soon as we can. We're still figuring out, because we can't try everyone together, too many defendants to do that. is figuring out what's the first batch of defendants that'll go to trial. And we'll see how that goes. And then that's going to help people think through what they want to do. And if you aren't in that first batch, then you'd be in the second batch. And then we need to tee that up for trial as well. So Mr. Luemba will be letting you know what that scheduling looks like. But I know you've been sitting in jail for a long time. So my goal is to get you in front of a jury, or if you're working the case out, in front of a judge as quickly as I can. Do you have any questions?
Is this my first plea?
Pardon me?
Is this my first plea?
What do you mean by first plea?
I was aware that I get 3 pleas. Is this the first one? I haven't talked to Mr. Luemba at all.
Okay, well, we need to get Mr. Lu.
Incarcerated.
All right, well, thank you for sharing that with me. We need to get him to see you. There's not a 1, 2, or 3 pleas. You could decide at any time that you want to work the case out. You could decide tomorrow. You could decide in the middle of trial. What you're going to need to know is what's the state's offer and what is Mr. Luemba doing to try to change that? Because right now it's life. But we need to get him, Mr. Luemba, with you so you guys can talk more about that. But I don't want you to worry that you've used up your first plea and you only have 2 left. You will continue to be able to work the case out if there's an offer that makes sense to you on the table. If the state continues to offer you life, then we know what's going to happen. You're going to go to trial. You don't need to worry about the number of pleas. But if the state says, now, wait a minute, we've looked at this more, we're going to offer you X, maybe that's what you want to do. But there's not a limit on the number of times you can ask for an offer, and there's not a limit on the number of times that the state can change that offer as they learn more about your situation. Okay?
Yes, sir.
All right. But thank you for sharing with me that fact about Mr. Luemba. And thank you, Ms. King, for filling in.
Thank you,
Okay?
Your Honor.
All right. We'll see you soon, Ms. Jones.
Yes, sir.
All right, Mr. Regis, if you would come on up and if we could bring Mr. Maloney out. And Deputy Gordon, when we get through all these defendants, is it going to make sense to pause so you can move some people? Yes, please. Okay. Ms. Rios, I am happy to see you, but also disappointed that we messed with your Friday.
Well, since I was going to spend preparing for the trial, but since there's no trial, I hate.
Well, look at that. All right. I don't see, oh, no, I don't see Mr. App. Is there someone here for Mr. Marriott on the attorney side? And he may be online. I don't hear that. Okay. Better open Teams. Okay. Mr. Maloney, good morning.
Good morning, Your Honor.
Mr. Regis, you were an early adopter of hard drives and Discovery, so I'm assuming you're good with Discovery.
I would not share that assumption, Your Honor.
You never submitted a hard drive?
Yes, we have, but as of yet, we don't have Discovery as of yet, Your Honor. However, I'm very confident I'll get it soon.
Okay. Is it possible someone from your office picked it up? Because my records are that people are nodding.
I have an affirmation from someone in my office who said it was dropped off.
Okay.
Everything I said was wrong. We have Discovery, Your Honor.
Good.
Story of my life.
All right. That's all right. It's voluminous and you are busy. Those are bad combos. But you do have Discovery. Mr. Maloney, I'm sorting out 2 things today. One is, does your lawyer have Discovery? Because that's what he needs to spend time looking over and talking with you. What are the goods the state has on you? Much, none, a lot? Because that informs his judgment on, we need to work this out, in his opinion, or we should take it to trial. Because if they're offering you this, there's nothing in here. We got a great case. Let's go defend it. So that's Mr. Regis processing the Discovery and talking to you about it. The other thing I wanted to make sure is that Mr. Regis had received an offer. I don't know if it's been formally communicated, but I also know that you, Mr. Maloney, are one of the several defendants in what I call the counts 1 through 10. So you've got a murder charge, which means the offer is going to be life. And unless you're interested in pleading to life right now, the message to me is we should move your case forward towards trial. Is that a fair assumption?
That is correct, Your Honor.
Okay, all right. Then I think the last thing is, a little bit later this morning, Mr. Maloney, we're going to talk about bond. Mr. Regis is going to share with me why he thinks you ought to get a bond, and someone from the DA's office will give me their thoughts about whether you shouldn't get a bond or what that bond should look like. We've had this conversation before, and I know at that point there was an inquiry about where it is you might stay, and it may be there's more on that, but we're going to revisit that discussion. Okay?
All right.
All right. Any questions about any of that?
No, sir.
Okay. I'll see you a little bit later this morning.
Thank you, Your Honor.
So Mr. Marriott is in custody, but I don't see his lawyer. Good. And Ms. Nelson's going to be reaching out to him as well. So we'll come back to that. Mr. Sharp, you and Mr. Miles Pratt are next.
Yes, sir.
If you could come on up. Ms. Warlick, it's just alphabetical. It's not you.
Oh, no.
And it's not your last name. It's your client's last name. Because then Mr. Apt would be first. Yep, switch around. Good morning, Mr. Miles Pratt.
Good morning.
How you doing?
I'm good. How about yourself?
Busy day. Sorry to have kept you waiting. Mr. Sharp, we good with discovery?
Yes, sir.
All right. And have you received an offer from the state?
I have.
Okay.
I'm trying not to start a fight when there's no fight. I dealt with
A fight when there's no fight.
Yeah.
Good. Don't.
No, I'm not going to.
Okay.
I assume everyone is on the same page or will be on the same page. I had discussions with the prior district attorney about the case.
And when you say prior, who would that? You're not referring to Paul Howard.
No.
No,
Assistant district attorney, Mr. Hiles. When this case began, Mr. Hiles.
Oh, Mr. Hiles,
Yeah.
right. And that didn't transfer over to, because I know we have Ms. Ocom today, and there's this Hicks name, but Mr. Abate had taken some pretty serious stewardship, and the Hiles discussion didn't transfer over to
I
Abate?
believe it did.
Okay.
I believe it did.
But it didn't go past that.
Well, I'll put it like this. My discussions with Mr. Hiles, I think, made Mr. Miles Pratt probably not the priority, because it had been worked out. So, I've had brief discussions with Mr. Abate, but there's certain things that need to happen.
Okay.
And I'm assuming when I sit down with Ms. Hicks, that will hopefully go smooth.
Okay. Ms. Ocom, is Ms. Hicks the person to whom these many lawyers should be directing their inquiries and conversations?
I apologize, Your Honor, I was muted. Yes, so Ms. Hicks is assigned to, but because of how big the case is, Ms. Hicks and I will be trying the case. So if they CC both Ms. Hicks and I, then it will be fine.
Okay, so you and Ms. Hicks, but nothing wrong with reaching out to Ms. Hicks. As you said, because of its sprawl, you'll be partnering with her, but she would be the go-to person to figure out where we're going.
Yes, Your Honor.
Okay, but she could not be here today,
Yes, Your Honor.
despite being the gang prosecutor assigned to this courtroom.
Your Honor, I apologize. She's out this week. That's why.
Okay.
So I'm
All right.
covering the calendar, not because she's not wanting to come. It's just she's not available. She's not.
I didn't think it was because she didn't want to come. It's just, it's complicated timing. We managed to get 45 defense attorneys all in one place, and then the person they all want to talk to can't be here. But it is what it is, and I won't bring it up again. So, Mr. Shart, it sounds like you need to have some conversations with Ms. Hicks. I don't have a crystal ball, just some experience, Mr. Miles Pratt being someone who goes to trial.
I don't foresee that either.
I also don't know where he'd fit in, given the chunk of charges he has. He wouldn't be in the 1 through 10. He's not charged in 1 through 10. That first murder, he's not charged with. So you've got discovery, you need to connect with Ms. Hicks, and it sounds like that's where we are.
Yes, and Your Honor, I'll also say that I have recently filed, so it's probably not on your radar, I think we filed it yesterday, a motion to modify Mr. Miles Pratt bond in two relatively, my estimation, minor ways. So I will talk to the state, see if that's something they're willing to agree to, and if not, ask for a date for a hearing.
Okay, yeah, please start with Ms. Hicks. It is in the docket now. You've been doing well at Next Level?
Yes, sir.
Good.
And I spoke to Mr. Davis yesterday, and I see Mr. Miles Pratt at Next Level too. So I think he's doing well, and he's seeking to attend an out-of-town event with Next Level with Mr. Davis, and also attend church once a week.
Okay. Poor Mr. Davis was stuck here most of yesterday. Okay, I see those requests. 100% need to hear from Ms. Hicks, and it may be something that she's comfortable with. And then an email to Ms. Nelson to that effect. We can get an order in there. Okay. Don't change anything till you get that order. Okay. If you don't have any other questions, we've done the final plea thing, and we just need to have you and Ms. Hicks see where you get.
Yes, sir.
Okay.
I'm going to stay with you because I have another case. May Mr. Miles Pratt be excused?
Yes, I just want to emphasize the importance of adhering to your bond conditions. It is significant that you're out on bond. You may have noticed a lot of folks coming through that door. So do what you've been doing. I'm not saying I've heard anything problematic, but don't loosen up on it, okay?
All right, thank you.
All right, we'll see you around. All right, and last but not least, Mr. Shannon and Ms. Warlick.
Morning, Your Honor.
Good morning. How are you?
I'm all right.
Good. Good to see you. Sorry that we're running a little behind, both of you.
No worries.
So I know, Ms. Warlick, you've got discovery. You, along with
Mr. Hoover.
Mr. Hoover, were the two to layer us with some motions. We've argued those. I've ruled on them. And we had a good conversation about the need for severance and what a first tranche of defendants might look like if when we're going to trial. Mr. Shannon, unfortunately for him, is in that 1 to 10 count. So I'm assuming the offer has been life for Mr. Shannon, unless you've got something different. But I need to make sure Mr. Shannon is saying, I'm not working the case out today.
That's the offer we received about 20 minutes ago, Your Honor. I would like to at least track with Mr. Mitchell's case and see if we can have an opportunity to present some mitigating evidence or something to get this back before you for a resolution.
Sure.
Opposed to packing us all in.
No. This is really how it's going to be for everyone. I appreciate that a number of the young men who came out here, and one young woman, said, I'm not interested in life, but things are going to be fluid and they'll change. And if we get to the point where there could be a plea, I'm going to keep final plea rights open for everyone.
Your Honor.
Because either people were presuming this was the offer, or let's say in Mr. Miles Pratt's case, it seems like maybe the offer has shifted a little. And I don't think, other than confirming that we're good to go with discovery, even Mr. Regis, we are going to treat this as we're probably going to have to meet again to figure out, is there a non-trial resolution? Okay?
Okay.
But that might be a trial calendar date. I don't know that we will try to recreate the magic of getting everyone here all together. That's difficult. When the state says, these are the 4 we're going to try, then the call of that calendar would be sort of the final plea date. But that's when it's much more crystallized. Everyone's knowing, hey, it's either we're going to trial or we're working it out. So I think that's probably how we'll do it.
One request.
Yes, ma'am.
Before I leave, is there someone that can get me Ms. Hicks's contact information?
Yes, we'll make sure. We don't need to get it into the stratosphere, but Ms. Willingham, if you don't mind using one of Deputy Gordon's note cards and just whether it's a phone or an email address, It was news to me too, that she's on the case. So we'll all be connecting with her soon and hopefully she'll get traction. But you've got the momentary advantage of knowing more about the case than she does. So figure out how to do something with that. Mr. Shannon, you are the other person on bond right now. Unlike Mr. Miles Pratt, your charges, they're all serious charges. Yours are more serious. And so you need to be 110% on point with complying with all the conditions of your bond. I'm not saying that because I have concerns. If there had been issues, they would have been brought to me long ago and the state would have jumped on it and we'd be having a hearing. And we're not doing that. So whatever you've been doing, keep doing it. Keep your head down, stay away from the people you're supposed to stay away from, make good choices. Easy to say, not so easy to do, but you've been doing those not so easy things for a while. And I urge you to keep doing that. Otherwise, Ms. Warlick's going to clobber you. Okay? All right. Ms. Warlick, anything else?
No, Your Honor.
All right. Thank you.
Thank you.
All right. We'll see what we hear about Mr. Apt. Are there family members here for Mr. Marriott? Yep. Okay. Have you all heard anything from Mr. Apt?
Yes, he's actually in the courtroom right now, so he should be on show.
Great.
He just texted me, he's on his way from Japan.
Well, look at that. Okay. Then we'll get him in here shortly. In the meantime, let's keep pressing through this. Travis Nelson.
This is not when you're ready to go.
All right. Mr. Nelson, can you turn your camera on, please? I do see him. He's there. Oh, camera just turned on.
Cool. Hi.
Hey, Mr. Nelson, can you hear us?
Yes, sir. Can you hear me?
I can hear you. So let me get your lawyer on the screen as well. Yesterday, you guys made the camera go away because you were unhappy with it. Can you make it come back? Thank you. All right. Good morning, Ms. Rivers.
I think my attorney is Miss Woods.
It is. Ms. Rivers is the court reporter. I'm just making sure she's on.
Sorry.
And she is. Ms. Rivers is actually pretty knowledgeable. She would not do a bad job as your lawyer. She has been in court for many more years than Ms. Woods, but you wouldn't know it if you saw her. All right. So let's get on the record in your case. This is 25 SC 002 442. Mr. Nelson is charged with criminal damage to property in the second degree, family violence battery, first offense, not first offender, and criminal trespass. Your lawyer, Ms. Wood, is on the screen, and then Ms. Smith is the prosecutor. Is this your case? It's Ms. Willingham. Correct that. Ms. Wood, we're going to start with you. Discovery, any concerns?
No, Judge. I did let Mr. Nelson know when I spoke with him this morning. Miss Willingham kindly sent me some stuff that she had received very recently from the victim. I didn't have a chance to go through it with him before today, but he knows about it. And so we'll go through that hopefully next week.
Is this something that is going to change the way you think about what Mr. Nelson should do?
No.
We can keep going forward with final plea.
Yes.
Okay. Ms. Willingham, what is the state's offer today if Mr. Nelson wanted to move forward with a plea?
Your Honor, the state's offer would be stacked misdemeanors. So we would be reducing count 1 to another criminal trespass, and it would be an overall sentence of 3 years probation. Complete family violence intervention program, no contact directly or indirectly, to include no communication via social media with the victim, and to complete 60 hours of community service. And we would be agreeing to early termination upon completion of all terms of probation.
All right. Mr. Nelson, were you able to hear that?
Yes, sir.
Okay. And Ms. Wood, this is something you've had a chance to share with Mr. Nelson.
Yes, Judge.
Okay. So if you were inclined to enter a plea today, Mr. Nelson, it would be 2 misdemeanors, and the recommendation would be 36 months of probation with the conditions you heard, and the probation could end early as soon as you met all those conditions. Is that something you are interested in pursuing today?
I'll talk to my lawyer more about it, but not today.
Okay. I respect that. And there's no reason why in the future you cannot enter a plea. The only thing that changes after today is you do not get to withdraw your plea if you're unhappy with the sentence. The state's offer may remain open. I don't control that. Ms. Wood will keep you posted on what she thinks the likelihood is that the state will continue to agree to reduce that felony to a misdemeanor, which is the big move here. But she'll keep you posted as long as you tell me you understand that that may not be the offer next time, and that you also understand that if you do enter a plea next week, next month, whenever the trial calendar is, you don't get to withdraw that plea if you don't like your sentence. You understand that?
Yes, sir. Do you mind if I ask my lawyer a question? Hey, Miss Wood, would this be a good time for me to
Whoa,
discuss?
don't talk about the case.
Okay, cool. Thank you.
So I will see you again at the latest in mid-June. We've got a trial calendar in mid-June, and that's where this case is going. Between now and then, you and Ms. Wood will be talking about it. And if you guys work something out, we do not need to wait that long, okay?
Yes, sir. Thank you so much.
Ms. Wood, anything else in connection with Mr. Nelson's case?
No, Your Honor, thank you.
We will move it to trial. Thank you, Mr. Nelson. You're free to go.
Thank you.
Joseph Varner.
He's actually in custody, Judge, on a different case.
Okay. Tell me what we're doing, Mr. Varner,
Final
today.
plea hearing.
Final plea hearing. Let's bring him out.
What? He done that warrant, but he was, being operated as a case. We added him. Thank you.
This is here.
Real quick.
Good morning, Mr. Varner. If you come stand next to Ms. Wood, please.
Sir.
You doing all right?
Yes, sir.
Okay. We're going to get on the record in your case now, Mr. Varner. It's 25 SC 007-132. You're charged with shoplifting and giving false information to a police officer. Ms. Wood is here in court with you, and Ms. Smith is representing the state. Mr. Varner, today is your final plea date. This is the last day you could enter a plea and withdraw that plea if you didn't like the sentence I gave you. So you can always plead this case out later. That may be how this one works out. It's just in the future, if you enter a plea and my sentence isn't what you were hoping for, that's the sentence you're stuck with. Do you understand that?
Yes, sir.
Okay. Ms. Wood, do you have what you believe is all the discovery in this case?
Yes, Judge.
No concerns?
No, Judge.
All right. Ms. Smith, what is the state's offer today?
The state's offer is 5 years to serve, 1 with the balance probated.
All right. Mr. Varner, you understand the state's offer is the one driven in part by the number of shoplifting convictions Mr. Varner has?
Yes, Judge.
Okay. So, Mr. Varner, the state's offer 5-year total sentence, 1 year in custody, followed by 4 years on probation, driven in part by, it sounds like, your criminal history, but it involves you being in jail for a long time. Do you feel like you understand the offer?
Yes, sir.
Is that something you're interested in today?
Yes, sir.
So Judge, I know this will be a plea, but I want to try to wrap up the new case. He was arrested less than a week ago. It's similar to this.
Okay. You got some new charges out there, Mr. Varner?
Yes, sir.
Okay. Ms. Wood is asking that instead of we take your plea today, see if she could get those new charges, get them assigned here, and do what we call a global resolution.
Yes,
so that you aren't picking up consecutive sentences, but try to get everything to run together.
Yes,
You
sir.
okay with that?
Yes, I am.
Okay. Then we're going to do that. Mr. Varner, have you been prescribed any medicine while you're in the jail?
No, sir.
Should you be getting any medicine?
No, no, sir.
No? Okay, I just want to make sure if you were supposed to be taking if you were taking medicine before you got arrested, I want to make sure you're getting it at the jail. You're good?
Yes, sir.
Okay, all right. Ms. Wood, anything else on behalf of Mr. Varner?
No, Your Honor, thank you.
All right, so you'll let Ms. Nelson know if you and Ms. Smith are able to sort something out with the PI case?
To get a waiver to her and I will get that to her. So.
All right, thank you. Mr. Varner, at the latest, I will see you in the middle of June. Your case, this one that's indicted, not the new one, but this slightly older one, is on our mid-June trial calendar. So that'd be the latest I see you. And it sounds like you're gonna work this stuff out anyway. But if Ms. Wood is able to work some magic and make it move faster, then I might see you before then so we can work everything out.
Yes, sir.
All right? You good to go?
Yes, sir.
All right, so I'll see you soon.
Okay.
Okay.
Thank you.
See you soon.
Robin Johnson.
Should be, yes.
Is this also a final plea?
Yeah. Yes, Judge.
All right. Mr. Suggs worked his case out, isn't that right?
Yes.
Ms. Rios? All right. Good morning, Ms. Johnson.
Good morning.
How you doing?
I'm all right.
Good. Let's get on the record in your case. It's 26 SC followed by 4 zeros and 84. And you're here in court with Ms. Wood. Ms. Smith represents the state. You're charged with aggravated assault and possession of a firearm during the commission of that aggravated assault. Ms. Wood, do you have all the discovery that you think is out there?
I do think I know what the state has. Judge. I spoke with Ms. Johnson this morning before court. She has some videos that she is gathering for me. So I did tell Ms. Smith that I would get her that information whenever I receive it. So I would ask that we just preserve the final plea rights.
Okay. Ms. Johnson, these videos that Ms. Wood is talking about, are they videos that people were taking with their phones or are they from a Ring camera? Where'd they come from?
The videos people were taking with their phones.
Got it. And have you already given them to Ms. Wood or you're hoping to get them to her soon?
I'm hoping to get them to her soon.
Okay, where would they be now?
Right now, I have the video on my phone.
Oh, so you're just trying to figure out how can I get it off my phone so it can be shared?
Yes.
Got it. All right. I'm asking not to get into your business with your lawyer, but if you were to say, well, they're in Tennessee right now, it needs to move kind of quickly because your case is on this June trial calendar you've heard me talk about. And if it was going to take months and months to get it, that wasn't going to work out. But it sounds like it's literally just a technical issue of maybe in your handbag right there, and we need to get it from place to place.
Yes.
Got it. In your sense, Ms. Wood, is that the videos are substantive enough that we ought to keep negotiations flowing?
Yes.
Okay. Ms. Smith, any objection to keeping Ms. Johnson's final plea rights intact?
No.
Okay. Ms. Johnson, we will do that. I want to look up your case real quickly to make sure, given what the charges are, you are doing okay with bond. So your bond, are you still wearing an ankle monitor?
I am.
Okay. Well, fortunately, we're resolving your case soon because we kind of hit the 6-month mark. And you're supposed to stay away from, I just have initials because it was a juvenile, CJ. You know who I'm talking about?
Mm-hmm.
Is that someone you're related to?
No.
No? Okay. It's not a problem staying away from CJ?
No.
All right. And an address on Cascade Road. You know the address I'm talking about?
I do.
Is that easy to stay away from as well?
Yes.
Good. Okay. Then no problems with bond. I will see you again mid-June at the latest, but if you guys sort something out, I'd love to see you sooner so we can sort it out then. Any questions?
No.
Ms. Smith, anything from the state?
Nothing further, thank you.
All right. Ms. Johnson, we'll see you soon.
Thank you.
Oh, do we still have a good address for you? Have you moved since you've been on bond?
No.
So give me 1 second. Lone Oak Avenue.
Yes, correct.
All right. We'll see you soon. Ms. Shalenje? Mr. Tiku?
Good morning, Your Honor. My name is Bukola Jayasimi. I'll be standing in for Attorney Tiku. He's at an immigration court hearing this morning.
Okay. Do you know where your client is?
Yes,
I'm right here. I'm here. I'm here.
Got it. You are iPhone.
Yes.
Excellent. Okay. Then I think we've got who we need. Can you pronounce your last name one more time, Counselor?
Jayasimi.
Oh, sorry.
It's Jayasimi.
All right, Ms. Jayasimi, have you had an opportunity to talk with Ms. Smith? Ms. Smith would have sent an offer to Mr. Tiku. On final plea date is when we talk about whether Ms. Shalenje is interested in working the case out based on what the state's offer is, et cetera. And Ms. Smith would have sent that offer to Mr. Tiku, not to you, but of course he could have forwarded it to you. Did you end up receiving that from him?
Yes, Your Honor.
Okay, and you discuss it with your client?
Yes, Your Honor.
Okay, so is today a day we're working the case out, or is today a day when Ms. Shalenje is saying no, thank you?
Ms. Shalenje is willing to accept the plea. However, she has a related case with the state court, so we'll be seeking to consolidate the cases so she can take a global plea.
Were you aware of that, Ms. Smith?
No.
Do you have the case number, Ms. Jayasimi?
Yes, for the state court, it's 25CR003136K.
Okay, and does it involve the same victim, or it's
Yes,
completely unrelated?
Yes, Your Honor, the same victim.
Okay. That didn't work. What did I do wrong? I have, you said 25CR00, it's too many numbers.
36K.
Oh, I added an extra one. Thank you. Yes. Okay. Look at that. Your firm is involved. There's Ms. Shalenje. Okay. And you are hoping to handle both those.
Yes, Your Honor.
All right. A little bit of a curveball, Ms. Smith, but I have jurisdiction over misdemeanor, so we can certainly do that. We just need to check with Judge Wolf. I can't imagine he'd say anything other than, you want to take one of my cases?
Okay.
Sure. But you didn't necessarily craft an offer that reflects that there are two situations.
That's correct. I knew about both of the situations, but this offer was specifically for this case.
Okay, well, why don't we do this then? My proposal, Ms. Jayasimi, is that we preserve your client's final plea rights. I'm going to keep this on the trial calendar. It's the mid-June trial calendar. But in the meantime, I can reach out to Judge Wolf to see if he's willing to let me handle the state court case. Ms. Smith can spend a little time learning about that case, maybe talk to the solicitor there, and then get back to you. Would she reach out to you, or is Mr. Tiku going to plug back in?
She could reach out to me.
Okay. And I guess you can get her contact info.
Yes, I think I have her email address already.
Okay, great. Ms. Smith can reach out to you to talk about what a global offer might look like.
Thank you, Your Honor.
Okay. Ms. Shalenje, do you have any questions about what we talked about?
No, sir. Thank you.
Well, don't thank me yet. All I did was say I will see if we can combine them. The magic will be when we resolve the case, but you're welcome. So we'll see you at the latest, Ms. Shalenje, in mid-June. which is when this will be on a trial calendar. And ideally, we'll get that state court case brought in here so you can resolve everything at once. In the meantime, I need to make sure that you are complying with the conditions of your bond, which I just found, and you are supposed to, no violent contact. It sounds like with relatives of yours.
Yes, sir.
Good. And I signed it, so hope you're doing it.
I am.
Good. Okay. Ms. Jassimi, anything else on behalf of your client?
That will be all, Your Honor.
Okay. Ms. Smith, will this be yours? It sounds like it's family related.
It is not intimate partner, they are siblings.
Siblings, okay.
That'll be mine.
You're keeping it, fantastic. We will see you all next. If it's the trial calendar, you're gonna need to be here probably in person unless you live awfully far away, but you don't. Roswell is close. So just know that for the trial calendar, I'll need everyone here in person, okay?
Okay.
All right, thank you both. You're free to go.
Thank you.
All right, and we took care of Mr. Suggs. So I think that means, oh, and we have Ms. Clark. Did Ms. Clark, is she here?
Yes.
Okay, and I think all we were gonna do in that case was to figure out the latest with the phone extraction. Was there more than that?
I don't believe so.
Okay.
No, no. and-
Okay, I didn't mean to drag you all in because I thought over email you were explaining.
At the time, we didn't have it, and then we subsequently got it, I think maybe 2 days later.
And it's going to Georgia Tech.
Yes, but we've gotten it back from them. I have.
That was fast.
Very.
The smart people there. Yep, send it to Georgia State, they'll still be figuring where's the on switch.
So we have, sent it over to, defense. I started going through judge, but I would imagine they haven't gotten through it because I haven't yet. But all that's turned over, so we are good to go on discovery. It's on chain, we still have the outstanding immunity motion.
But now we can schedule it. I mean, you need to digest the discovery. It's a phone's worth, so I don't think that's 1 minute. But right, that's been, holdup's the wrong word, is all due process. But we need to schedule the immunity hearing, and I need to work through, does that go to our judge who is our immunity hearing master? Do I keep it? But either way, I want it to happen soon because this is a complicated case for the family, and we've got a defendant on bond with these serious charges. So any reason I can't try to hurry up and schedule the immunity hearing, Mr. Sharp?
No, I have some leave scheduled.
Well, we need to be consistent with everyone's schedule. The discovery isn't such like, I need months to get through the phone.
It's not that situation.
Okay.
I'll begin going through. I downloaded it yesterday.
Okay.
So that's all to do.
For whatever date we schedule it, which is not today, you can be ready for it.
Absolutely.
Okay, well, we'll look at everyone's leave schedule. I will check with Judge Dempsey, to whom we send lots of immunity motions. If he is off into August for when things would be set, then I may see if I can do it. Just the issue is, if I hear it, I need to do the order, and I'm happy to do the order. I may then be doing the order for a different judge. And so I need to check with that judge to see if she wants to be the one who hears it instead. We'll figure it out, okay? Anything else, Ms. Willingham, about the case?
No, Judge, I would like to acknowledge that the victim's son is present today, but other than that, nothing further.
Okay. Where is he?
Mr. Murray Clark.
Hey, Mr. Clark, how you doing? Good seeing you again. You doing all right?
Yes.
Good. No issues with bond conditions or anything like that? Meaning you are able to lead your life the way you want to lead your life right now?
Yes.
Okay, good. That's all I meant by that. The district attorney's office will keep you posted as to whatever's next. The next big event, and it's a big event because it's basically a mini version of the trial will be the immunity hearing. You may well be a witness in that. So you may not be a spectator, but an actual participant. That's not my call. That would be the lawyer's call. But just to prepare you for that, you might be called upon to testify about what you saw and heard with that situation. Okay? And if so, and I handle it, I'll see you then. All right. Any questions about anything? No? Thank you for being here. Anything else, Ms. Willingham? All right. Mr. Sharp, anything else?
Oh, Your Honor.
All right, you're doing what you need to do with the bond?
Yes, sir.
Good, appreciate you all being here. I will make a note to take a look at schedules.
I'll be right back. I'm just gonna.
Good.
Go to the next case, whatever.
All right. You're good to go. Thanks.
Thank you.
May I be excused, Your Honor?
Yes, sir, thank you. And you'll reach out to Ms. Hicks, and then you will let me know, copying Ms. Hicks, if there's a big disconnect, so we don't get a, wait, there was this kind of discussion and now that. Thank you. Yes, Ms. Wood.
Request. If you'll hear it. So I have two people on the afternoon calendar. One is just a re-indictment announcement, and then the other one is a very quick final plea hearing. And I believe if we're able to handle those, then the deputies can take them down with the first batch of people.
Okay.
Or whatever the court is ready.
So if they're really quick, we'll do that. Mr. Cotton was, I don't know if there are people here for Cotton again, but we were going to do that.
Here.
Good, she's here. All right. So why don't we do so one is just saying we can't do final plea because there's a new indictment, and then the other is a no thank you final plea. All right, is that helpful to you, Deputy Gordon, if we do that? Well, that's really what matters. Who are those people?
Yes, Newton position 7 and 8 on the 1 p.m. and then number 10.
Okay, that must be the re-indictment.
Yes.
So let's bring Mr. Foster out first, please.
Maybe that's fine. I know, I do. I think this morning, but he didn't work. So we'll see.
I don't have a re-indictment in the system yet.
It's not there.
Okay, is that fresh or you're told, well,
Okay.
we don't need to get it on the record. You can just talk about it with him here. Good morning, Mr. Foster. We were going to have a discussion about your case and has the state provided all the discovery? What's their final offer? That kind of stuff. But Ms. Wood had an update for me that she may have shared with you, but I want her to give me the full update. I said, well, let's just get Mr. Foster out here so we could talk about it. Something about a re-indictment.
Yes. So I have been working, this is actually Ms. Willingham's case, but Ms. Smith, I'm confident can fill in because Ms. Willingham knows that I was gonna tell you all of this.
Sure.
We've been working on this case actually for a while now. We were trying to get to a resolution. She received the medical records and some additional photographic evidence from the victim in this case. It looks like there will be an addition or an aggravated battery will be added to this.
Added. So it's not getting better for Mr. Foster. It's getting more complicated at
More
least.
complicated. She's shared, since we had a bond hearing for him recently. And so after that, she's shared a lot of discovery, some videos.
Ms. Gaffney has.
Yes.
She's provided information to the state.
And I've gotten it now.
Good.
Yes.
Okay.
Lots of photos and videos, and I also got the medical records recently.
Okay.
So Mr. Foster's aware of that, and so, yes, that's why we're not able to
Okay.
do final plea.
All right. So Mr. Foster, it doesn't make sense to say, hey, do you want to work this out? Because the state is on the verge of expanding the charges a little bit. That's not going to slow things down a whole lot because the state has already provided all that discovery. But we need to get that indictment filed so that Ms. Wood can waive arraignment. That's you entering a plea of not guilty. And then we can fast track it back to what we were going to do today. We'll skip over some of the other stuff because your lawyer already has discovery and has determined there's nothing that she thinks should be suppressed, no confession or anything like that that maybe should be excluded. And we'll get you right back in here to have that discussion of, is this something that can work out? Or the state's offer is here and your thoughts are over here. Then we need to get you a trial, okay? Did you follow what I said?
Okay, a little bit.
Tell me where you're confused. I'll try to do a better job.
I think you said, we trying to see what we can do, like, what the offer is, or what I'm thinking.
Yeah. So right now, the state may well have said, I'm making these numbers up. Hey, our offer is 5 years to serve 1 year. And you might be thinking, no way, I'll go to trial. I'm not serving time on this. I didn't do it, or it was self-defense, or whatever you may be thinking. What the state's offer was based on what's not the full universe of charges. They're adding another charge, and it's a serious one, so their offer may change. And so Ms. Wood's not in a position to say, hey, you should take that yet, because not all the charges are in there. Once all those charges are in there, and this happened real soon, then I'm gonna ask the state, make your offer, because we'll reschedule what we were gonna do today. Ms. Wood will talk with you about that. She'll give you her sense of, this is as good as it's gonna get, or that's way too high, I disagree with it, you've got a good defense, and we can have the conversation that we were gonna have today. We just need to get that new indictment there so that the state can make its offer, and then you can react to it. Does that make more sense? The good news is it'll all happen real quickly. I know you've been in for a while, but we're not gonna reinvent the wheel. Your lawyer already has all the discovery that supports this new charge, okay? Other questions about what I said? I don't mean to leave you confused.
You said we waiting for this new charge to get indicted. Or y'all give me an offer.
Well, yeah, the offer won't come from me. It'll come from the prosecutor. Ms. Willingham, do you have a sense of when the re-indictment would happen?
Yes, Judge, I was hopeful that we would have been able to do it this week. We did not have anyone for me to present it to, but I expect to get the new indictment by the end of next week, and I should have an offer within the same amount of time. I have a general idea, but I want to make sure I finish the indictment.
Sure. Just so happens this week there was not a grand jury. They brought in new grand jurors, and so this was a slow week on the grand jury front. It'll be a fast week next week. Ms. Willingham has told us the new indictment will be next week. Once she's got that, she'll deliver that and an offer to Ms. Wood. And then Ms. Wood can let me know when we should put this back on for final plea. I mean, technically we need to do an arraignment, but if you waive arraignment, we will move it quickly. Okay? Any questions about any of that? No? All right. We'll see you soon.
Thank you, Judge. I'll be back to see you soon, Mr. Foster.
Okay. I see.
And you said Newton was the other one?
7.
And that's just go to the trial calendar?
Yes.
Okay.
Oh, she can do it. That's why you should have just stayed at home, Ania.
Look at his performance. Yeah, he probably wasn't that good.
You're gonna see that on YouTube now, Ania.
Mr. Newton, good morning. We're going to get on the record in your two cases. You are indicted in 26 SC 000040 for terroristic threats, criminal trespass, and reckless conduct. You've got a second indictment, 26 SC 000309. And in that, you're charged with aggravated assault, a couple firearms charges, and reckless conduct. Ms. Wood, do you feel like you've got all the discovery in the two cases?
I do, Judge, and I told him when I was speaking to him this morning, my investigator took his copy of initial discovery to the jail this week, and I realized this morning when I was going back through his case, I think I might have left off the discovery for the second one for him, but I will get that to him after today.
Okay, so you're entitled to all the discovery that can be brought into the jail. So if there's a video, you obviously don't get that, but all the paper discovery, Ms. Wood is doing her best to get it to you. And she may have forgotten, wait, case number 2. So she'll get you the rest of that. Most importantly, she's got it. So she's had a chance to evaluate it and share with you her thoughts about it. Ms.
Me.
Smith?
Yes.
Is there overall offer if Mr. Newton were inclined to resolve both cases?
It is, Judge. The offer is 10 years to serve 3 with the balance probated.
Got it. So, Mr. Newton, if you were to enter pleas today in your 2 cases, the state would recommend that I sentence you to 3 years in custody, followed by 7 years on probation. Do you understand what the state's offer is?
Yes, sir.
Are you interested in pursuing that today?
No, sir.
All right. Well, your case is going on to our mid-June trial calendar, so you will be back soon. On that date, we'll be figuring out which of these 2 cases, because they can only try one at a time, the state wants to try first. And Ms. Smith will let Ms. Wood know in advance, because Ms. Wood's got to get ready for that. That doesn't mean you cannot work the cases out. You may still enter a plea, but you need to understand 2 things about what changes from today. One, after today, if you enter a plea, you may not withdraw that plea if you don't like the sentence I give you. As long as my sentence is legal, then that's the sentence you get. Number 2, this offer of 10 serve 3, that's the state's offer today. I don't know if they're going to keep making that offer. They may make you a better one because they don't want to go to trial. It may get worse because they need to spend time with the alleged victims and that traumatizes them. But you need to let me know that you acknowledge that that's today's offer. It may not be tomorrow's offer. You understand that?
Yes, sir.
Okay. Do you have any questions for me?
Okay. As I find out on other charges.
So we had a bond hearing on this case to remember arraignment, so it's so close to the trial date. I doubt the court would be inclined
Right.
to
What
change.
my answer to bond would be, let's meet on the 16th, because you're either going to go to trial, and if the jury acquits you, you go home. If they find you guilty, then you weren't going to go home anyway. So I will see you on the 16th at the latest. If you and Ms. Wood work something out before then, we can take the plea then. Anything else, Ms. Wood, in connection with Mr. Newton's cases?
No, Your Honor.
All right, great.
Thank you. Right, I'll see you soon.
So, Ms. Rios, would you like to do Mr. Cotton's plea now, or should we do one of the bond hearings?
I would like to do this.
Let's do that. Mr. App,
Good morning, Your Honor.
good morning.
Happy Friday. How are you?
Better now that you're here.
Oh, very kind. Good to see you.
When we're done with this plea, we will bring Mr. Marriott out for the final plea conversation, which has been pretty informal for this case because no one is working it out quite yet. But he's here, you're here, and so I'd love to have everyone be together for a quick second.
Very good. Thank you, Your Honor.
You're welcome. Mr. Cotton,
Sir.
you ready to go?
Yes, sir.
All right, we're going to get on the record in your case. This is 25 SC 006-136. And Mr. Cotton, Ms. Rios tells me that you are prepared to enter a guilty plea. I think the state is negotiated with Ms. Rios some type of reduction on your behalf, but whatever it is, that's all going to be shared with me. Is that your understanding?
Yes, sir.
Okay. Ms. Smith will put you under oath in just a moment, and then she's going to ask you a bunch of questions about the case and your rights. You need to answer all her questions truthfully. You also need to let me or Ms. Rios know if at any time you've got questions because you're not understanding what's happening or you're confused by something. Will you do that?
Yes, sir.
All right. Ms. Smith.
Yes, Judge, before I start, would you like to know about the reductions in this case?
Yes, please.
Count 1, armed robbery, will be reduced to robbery by force. Count 2 will be no cross. Count 4, be reduced to battery.
I don't have the indictment in front of me. Is that aggravated battery?
Yes.
So aggravated assault is being dismissed. Aggravated battery is being reduced to battery.
That's correct.
Okay,
Count 6, kidnapping is no prost.
all right.
Count 8 remains the same.
And what's that?
Um,
Financial transaction card theft?
yes.
Okay, so it's a plea to robbery, battery, and financial transaction card theft. Understood.
All right, Mr. Cotton, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Devin Marquez Cotton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
31, GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Yes.
Mr. Cotton, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve for?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
What? Any charge with things you can affect the situation, so it could. So there's a warning of, yeah, there's something I have to tell you, everything can affect me.
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea?
No, yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
No.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Cotton, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 006136, how do you plead to count 1, the reduced charge of robbery by force? Count 4, reduced to battery. Count 8, financial transaction card theft.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Cotton. Your Honor, if this case were to proceed to trial, the state would show that on,
August 6th.
yes. If this case were to proceed to trial, the state would show that on August 6th of 2025, officers of the Roswell Police Department responded to a robbery call near Roswell North Elementary. That's at 10525 Woodstock Road, also in Fulton County. When the officers got there, they spoke with Miss Johnny Pierre. First name is spelled Adjanie. Last name is Pierre, Pierre. Ms. Pierre is the victim in this case. She told the officers that she was meeting with an acquaintance this day to open a bank account. They were supposed to, the idea was they were going to make money together. The victim said that when she met with the acquaintance, who is later identified as Ashley Chambers, also a co-defendant in this case,
Okay.
that when they met with each other at a Wells Fargo location, there were 3 other individuals in the car: Mr. Cotton, another co-defendant, Mr. Thomas, and the other co-defendant, Ms. Junicent. When she got into the car, the idea between all of them, they agreed that they were going to go and make some money, which means they were going to open bank accounts. When they opened those bank accounts, they were either going to deposit false checks or money in there that they would then withdraw and distribute amongst the group. So after a while, Mr. Cotton in this case was driving. They went to several banks. They went to Walgreens. I believe they went to a CVS, kind of just trying to open these bank accounts and withdrawing money from an ATM. However, Ms. Pierre, the one that was getting out of the car to open these bank accounts, would come back without opening the bank accounts or without the money from the plan that they had. Because of that, the individuals in the car, including Mr. Cotton, became agitated that the scam was not complete. At this time, the person, and I'll tell you where everyone was sitting. So Mr. Cotton was driving. Ms. Chambers was in the front passenger seat. They had Mr. Elijah Thomas sitting behind Mr. Cotton. Ms. Junicent was sitting in the middle in the back. And the victim in this case, Ms. Pierre, was sitting behind Ms. Chambers. So once the group grew agitated with the fact that the plan was not going as planned, Mr. Thomas, in this case, who's not the one taking the plea, but he pointed a gun at Ms. Pierre because he was irritated that she didn't get any money. So he said, at this point, give me all that you have. At this point, Ms. Pierre is asking them to not do anything to her. She don't have any money. She can call her family, try to get something, just let her out of the car. At this time, they began to tell her to be quiet, including Mr. Cotton. And she wasn't, she continued to talk. She wasn't being quiet. So Mr. Cotton reached from the front seat to the back and punched Ms. Pierre in the face. At this time, he then took her bag where she had her credit cards, her cell phone, and her ID inside of it. That bag was rummaged through both by Mr. Cotton and Mr. Thomas in this case. Eventually, and this all happened while Mr. Cotton was still driving. Mr. Cotton comes to a stop at a park near the elementary school and tells Ms. Pierre to get out. At that time, Ms. Pierre goes to the elementary school where she's met by a teacher that could see that she was in distress, that her eye was swollen, that something had happened. So she told the elementary school teacher that she needed to talk to someone in the administrator's office so she could call the police. And that's when the police responded to the scene. In this case, the state did get a chance to speak with other co-defendants who confirmed that Mr. Cotton in this case did not have a gun. They were all under the impression that Mr. Thomas didn't even have a gun. However, they all confirmed that it was Mr. Cotton who reached from the front to the back to hit Miss Pierre and then take her bag. After the bag was taken and the defendants left the scene, they went to a nearby gas station, crossing over into Sandy Springs. So we have a mix of Roswell and Sandy Springs responding to this incident. They go inside of the store and they buy several items. Some of it is paid for in cash, and some of it is paid by the chime card owned by Miss Pierre. After it was reported because they got a tag number. So now they're following the car through the city. They find it at this gas station. The officers of Sandy Springs respond to that gas station where they detain all of the 4 co-defendants.
So they're still together, the foursome.
Yes, Miss Pierre's out of the car, but the 4 of them are together. The officers are able to detain all of them, take them into custody, and Mr. Cotton was arrested for the charges we have before us. Again, all of this occurred in Fulton County. Now, those are the facts of the case regarding.
Before you move on, so Ms. Pierre says there's a gun, but none of the other 4, some of whom have spoken with you or spoke with law enforcement, confirms the gun.
The victim says it's a gun, and both Ms. Chambers and Ms. Junison and Mr. Thomas confirms that there's a gun. And
Oh, Mr. Thomas himself says, yes, I pulled a gun on her.
Mr. Thomas said that he has the gun. He doesn't say he points it at her, but it's confirmed that he has the gun.
He had a gun. Got it.
It
Okay.
confirms that he points the gun are the other 2 co-defendants and the victim in this case.
Got it. Okay. All right. You were going to move to something else.
Yes, Judge. Regarding the negotiated plea between the state and defense in this case, we're asking for count 1 sentence to be reduced to robbery by force for a sentence of 10 years to serve 4, balanced probated. For count 4, the reduction of battery, we're asking for 12 months to serve. And then for count 8, we're asking for 3 years to serve for all counts to run concurrent for a total of 10 years to serve 4. Regarding the special conditions of probation, the state is asking for the defendant to be banned from Fulton County to complete 100 community service hours, to stay away from the co-defendants in this case. And I believe the facts show that the victim in this case left around $140 in the car that may have been spent when they paid for the groceries, half with card and half with cash. And the state will just be requesting restitution in that case. But of course, we'll ask for a restitution hearing. But that is all from the state. And just to go a little further on the reduction we have here from armed robbery to robbery by force, what went into that is kind of the role that Mr. Cotton played in this case. As I stated, we did get a chance to speak with other co-defendants who confirm, and there are a lot of things that may be disputed, but what's not disputed is the fact that Mr. Cotton did reach from the front to the back to hit Miss Pierre and then grab her bag, go through it, and then use that car at a nearby gas station. Because Mr. Cotton is taking, I believe, accountability for his role in this case, the state is willing and was willing to reduce this case to robbery by intimidation. I also did speak with the victim in this case. She's aware of the reduction. She's okay with the reduction. She did want me to let the court know because she's at work. She can't join the Zoom, but of course, this armed robbery or this case here changed her life forever. She has gone to the I want to say the Grady eye doctors, where they told her that she did have some damage to her eye. We weren't able to get the medical records in this case. However, she does have, when you look at her and you talk to her, one eye is kind of lower than the other one, which is her right eye, which is the eye that she was punched in. She does want the defendants in this case to take responsibility. She is aware that that Mr. Cotton is pleading today. And she said that when she was in the car, it seemed as though they were acting independent of each other. So the girls were doing something different than Mr. Cotton, and Mr. Cotton was doing something different than Mr. Thomas, which also went into the reason why the state in this case was willing to reduce from armed robbery to robbery by intimidation. Oh, I'm sorry, robbery by force.
By force. Did Ms. Pierre own up to, hey, we all got together to do some scam?
Eventually, I was able to speak with Ms. Pierre, and she told me that they were going to scam. Who started the scam between her and Ms. Chambers is, it's a Spider-Man thing where they're pointing at each other.
Right, but she didn't say, no, I was getting a ride with him or we're going to lunch. She acknowledged that the group was there to figure out a way, could we create money from nothing?
That is correct.
Okay, all right, thank you so much. Ms. Harvey, you knew what was coming.
Good morning, Judge. How are you?
Good morning.
13 cycles. There's a 2013 armed robbery conviction and 2012 robbery. There does appear to be an additional open case out of Fulton County under case number 26 SC 002-106, aggravated battery, false imprisonment, and kidnapping. That offense date was from February 23rd, 2026, Your Honor, and nothing further.
Were you aware of the open case?
Yes, it's a case that happened while he was incarcerated.
Okay, and we're just not dealing with that today. That's for another day.
I think he's willing to accept responsibility for this. I don't know what's going on. It seems like I'm not sure exactly. I just found out about that one recently too,
But Mr. Cotton, you understand what we're doing today resolves what was going on in that car in August of 25. It's not resolving whatever your new situation is.
Yes, sir.
Okay, all right. So you were aware, Ms. Smith, when you made this recommendation of the prior armed robbery and robbery convictions?
I was, yes.
Okay,
We did file a recidivist notice in this case, and because Mr. Cotton is coming today, we are withdrawing that recidivist notice.
okay, understood. What kind of sentence did you get for that armed robbery back in 2013?
2013, I received a straight 10, non-mandatory 65%. I ended up maxing out.
So you did your 10 years?
Yes, sir.
And so you got out in 23? I don't know when you first went in.
Went in 2013, got out 2022. They gave me credit for time served. I had been locked up since 2012.
Right, okay, so you did 10 years.
Sir.
Okay.
The robbery, I never received any of that. Case was actually dismissed. I was never convicted for anything, never did anything for that.
Okay, well, you did a decade for the other one. That's a long time. And here you are in this car. Ms. Rios.
Yes, Your Honor. To get a little bit more context of what the facts of the case, I did go through all the discovery when I thought we were going to go to trial. And the victim in the case, Ms. Pierre, her story changed a lot. Initially, it was that my client wasn't the one who grabbed her bag. It was the co-defendant who was in the back. That the punch was she was like, oh, he wanted to quiet me up, or the punch was because she was trying to get out the car when he was driving the car, and he didn't want someone rolling out the car when he was driving. So the stories kept changing, but it was clear that it wasn't, to me, the punch was not to take her money. And she even offered him, instead of herself, that she offered them gas money. He wasn't the initial involvement of whatever the scheme was. It was between Miss Chambers and her, and the body cam or the videos I saw, it was they were having a mutual agreement to do this scheme. And then Mr. Cotton and Mr. Thomas were in the car, and I guess he wasn't really even understand how they were supposed to be getting money from this, but he was just there.
Me neither.
Yeah. So
Okay.
it wasn't between him, and once everything started being weird, her getting out of the car, he was just like, okay, what is this? It was that type of thing, and it frustrating. And when I spoke to Mr. Cotton, he let me know that he had a talk with Mr. Thomas, was like, hey, he knew that because of his theory, he couldn't be around guns. Don't bring guns, no guns in this car, nothing. And everyone was shocked when Mr. Thomas then pulled out a gun. Because he did do 10 years and he didn't want to be in the same situation, didn't want to have an armed robbery or anything
And
like
yet,
that.
right.
But being around the wrong people or people just being reckless, he is back in this situation. He was initially adamant that he wanted to go to trial, but the problem is if we lose, it's life without parole because of his history. So this has been a very hard decision from him, but because he maintains that it didn't happen exactly. He doesn't deny the punching, but that everything else, like, it's questionable, but it's not a risk that he's willing to take. He has children.
Right, as party to a crime. I mean, he doesn't need to have been the guy who pulled the gun. If in the end, the group is spending her money after she gave up her bag because someone pulled a gun on her and he's the driver of the vehicle to get away from her. All sorts of reasons why a jury would have stapled this case to you at the end of trial. And that would have been a real different outcome.
Yes, Your Honor. But he's 31 years old. He has a child who is a year and a half now. He also is a father figure to his stepdaughter, who is 5 years old. I did send you an email with his resume and his certificate. So he has things that he can do when he gets out. He plans on maybe even starting his own business. Before he was doing box trucks deliveries. And he's has all types of certifications that I sent you that he can use to secure employment. I know his history makes it hard, which is why we were discussing maybe starting his own business, but he wants to be there to be a father to his children. His fiance has been very supportive. She has called me numerous times, has been here all day yesterday, and she thinks she's on Zoom now. She's trying to go to college.
I'm here.
Okay, so she was trying to go to school. So their goal is to be a family and be productive going further. I don't know. Did you want to speak?
I can't really speak right now. Give me a second.
Okay. I know she's there with the child, but that's all I have. I just ask you to go with the sentence as negotiated. Now about the stay away out of Fulton, I'm going to ask maybe that not be a condition. I don't know if that would be hard for him because
Other stuff going on in Florida.
so if
Where would you're going to get out at some point. Hopefully you're done with things like this. Where would you be staying?
I currently live in Clayton County, so that's not a problem.
Okay.
But
Okay.
what I did want to say is since he has been out, he's been with me. And I've been trying my hardest to do everything I can to make sure that he plays by the book. So since he had his child, he has turned over a big leaf. And I will give him that. And the fact that he stepped in to be a father figure for my child, I also appreciate him for that. So he is not a bad person. And as soon as everything happened, he made sure I was the first person he called to make sure that I had a backup plan. So the only thing I ask is that, don't paint the picture that he's just a bad person, because he's not. Like I've been making sure that everything, has been going smooth. School, like I've been trying to talk him into getting school, anger management, everything. Like I'm very present.
Okay. Well, he's lucky to have you. You may feel a little less lucky that he got mixed up in this. He's got to make different choices about who he rolls around in a car with.
And trust me, I done said it already. So
I know you have. I'm not telling him anything he hasn't heard, but it's up to Mr. Cotton to act on the common sense that you would hope by age 31 he's got. If he has a beautiful little child with you and a stepdaughter that he wants to be present for, he takes himself out of those situations by getting mixed up with something like this. So I appreciate you being here, ma'am. Mr. Cotton, anything you want to add? Okay.
Sorry, I forgot to mention as a special condition of probation that the defendant is to testify truthfully in the trial that we have regarding the ban from Fulton County. All of the conditions that were part of the negotiated plea are the ones that the state is willing to go forward on, hence why for the reduction that we're doing in this case.
Right. The ban is part of we're reducing armed robbery to robbery. If you don't want to stay out of Fulton, plead to armed robbery. Okay. Those are your calls. Mr. Cotton, before I decide to accept your plea, and I'm inclined to do that, I want to make sure this the thing that one of the things that Ms. Smith just mentioned is they're all important, but this agreement to testify, you understand that it is a condition of the state reducing the armed robbery, life without parole, to robbery by force, that if you are called upon, you will come into court under oath and tell it like it is, whatever it was. Even though that's not what you might do naturally or not comfortable doing it, you need to talk about everything that went on in that car that day. You're prepared to do that? Because if you're not, that's okay. Some people aren't willing to do that. But then the state needs to know that, and then we need to not take this plea and instead do the trial.
Testify.
Okay. I don't know that that's going to be necessary, but you're saying on the record that you get it, that it's a condition of this outcome. Given that, I find there's a factual basis for your plea, and your plea is knowing and voluntary, meaning no one's forced you to enter the plea and you've understood the things we talked about. Do you agree with that?
Sir.
Any questions about anything so far?
No, sir.
All right. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Cotton, can we sign your name electronically to the indictment indicating your plea to the reduced count of robbery and the reduced count of battery and then financial transaction card theft?
Yes, sir.
We'll do that. And you said it before, I just want to double confirm, you're withdrawing the state's recidivist notice? All right. Mr. Cotton, I will go with the negotiated plea. Your sentence on count 1 is 10 years to serve 4 with the balance probated. Your sentence on count 4, so 2 is dismissed, 4 is reduced to battery. It's 12 months to serve. 6 is dismissed, and then 8 is 3 years to serve, and they all run concurrently with each other. So a total of 10 serve 4, you'll get credit for the time you've been in, which is a big chunk of the first year. Special condition of probation number 1, 100 hours of community service. Number 2, no contact with any of your co-defendants and no contact with Ms. Pierre. Are you related to any of the co-defendants?
I wouldn't say related, but I spent a lot of time with the family members. I've only known Mr. Thomas through the family members.
Whose family? Ms. Chambers' family? Ms. Junicent?
Thomas.
The Thomas family. Okay. Well, you can be with the Thomas family. You can't be with Elijah Thomas. Okay. And you will also need to stay out of Fulton County while you are under sentence. And you are agreeing to testify truthfully if called upon to do so. Ms. Rios, anything else in the case?
No, Your Honor.
Ms. Smith?
Nothing further, thank you.
All right, that's it. Can we bring out Mr. Marriott now, please? Mr. Abadi, thank you for being here. We are having a couple bond hearings in the case. Will you be covering those?
Yeah.
So we'll get to it, but you're here to cover whatever we do with bond.
Yes.
Okay.
Clear the record up about the offers and the things that were relayed
Okay,
inappropriately and.
we'll cover it. We're going to start with Mr. Marriott.
The offer has been provided.
The note was to your associate and the last 2 times. It was life. They would change, things wouldn't cooperate. Yeah. Okay, well, we'll be in touch about it. No. Hey, Mr. Marriott. JF, up over to the wall. How you doing?
All right. Good morning, Mr. Marriott.
Good morning.
How you doing?
Good.
All right. Mr. Apt is here, and we are going to speak briefly about where we are in your case. Let me pull up the spreadsheet. That's how big this case is. Mr. Marriott, you are part of the first part of the indictment. So you have a murder charge and a bunch of other charges related to that. Mr. Apt, early on, you did supply the district attorney's office with a hard drive. You got discovery. I've checked that off.
Yep.
So I think you're good to go on that front. It sounds like the state's offer to Mr. Marriott right now is life in connection with the murder charge. I'm assuming that's nothing he's seizing on today.
We're politely
Declining.
declining the state's offer for life.
Okay, so Mr. Marriott, we needed to get to this point where I've confirmed with all the lawyers for all the many defendants that they've got discovery. The state has pushed out offers to the lawyers, and people are processing those. A lot of the offers have been life because they're two different murder charges here. That means we are now ready to get this case to trial. What will be happening next is a conversation that I'll have with the prosecution to figure out which 4 or 5 defendants are going to go first. We can't try everyone together, but we are going to need to get the trial going. So I'll be working with the prosecution to figure that out, and then we'll certainly let the lawyers know. So for example, if you're in that first group, we'll need to make sure whatever the trial date is something that fits on Mr. App's schedule. This case has now gotten to be older, and so we might take some priority, although Mr. Apt has a big docket of cases, and we'll figure all that out. Do you have any questions about where we are or anything I just said?
No, sir.
Okay, Mr. Apt will be in touch. He will continue to work with the prosecutors. There's several working on the case about whether this is a case that could work out. And if it's not one that's working out, then it's really just scheduling those logistics so we can get the lawyers all in the same courtroom for a week or so to do this trial. Mr. Apt, anything else?
No, Your Honor, I may ask a question of the court, although the court may not be able to answer, just so I'm not I'm going to file my leaves for 2027 at the end of this year. And I'm just wondering if the state knows whether or not, once the court decides sort of which group to try first, if Mr. Marriott's going to be in that first group or not, and sort of when to expect just a rough estimate of when the state and the court might think that Mr. Marriott go to trial, so that I don't want to file a leave and then have the court have to move.
August 6th.
August 6th
is the trial date that I have been given for whoever goes first.
Of this year?
Yes, August 6th of this year. I'm not going to require Mr. Abadi to decide right here, hey, these are the 5 we're going to do. But as a focusing mechanism, August 6th is the date for, it says positions 1 through 10. So, I mean, collectively they'll move there, but everyone has heard we will not be trying all 10 at once.
And is that a specially set date?
TBD.
Got it. Thank you, Your Honor.
We will do what we can to protect that date. I suspect the answer is yes, it will be, but I'm not in a position to confirm that right now.
I'll further talk to Mr. Abate off the record and appreciate the court's
Sounds good.
advice.
All right.
Probably won't be the first group.
Look at that.
There you go. Things are happening. Mr. Marriott, Mr. App will be communicating with you soon about what's going on. All right?
Yes, sir.
See ya. So, Mr.
That's all my business.
You may.
Good to see you.
You bet. Can we please bring Mr. Maloney back out? Mr. Regis?
Yes,
You ready?
yes.
Yes, I can get you some flowers.
Slide that bag over here. I love it. You're back. Ms. Rivers, we're going to get on the record, please. This is position 7 from our final plea calendar, State versus Omar Maloney. And we're going to talk about bond. His lawyer, Mr. Regis, is here. We have Mr. Abadi here from the state. to give the state's perspective. We are picking up where we left off. Assume I don't remember all the specifics, so I invite you to refresh my recollection. What I do recall is that there was a robust discussion about bond, and where I got stuck at the time was something about where Mr. Maloney would be staying.
That is correct, Your Honor.
So you can take it from there, and I'll hear from both sides.
Well, at that time, Your Honor, there was a discussion about where Mr. Maloney would be residing. It was, as I understand it, the court's intention that Mr. Maloney not live in close proximity to where other certain people or another party resided. And at that time, there was an address that was gotten after the hearing, an address in, I believe, Stockbridge. Since that time, the person who provided that address has now moved. However, that being the case, we also have an additional address that met the concerns of the court, not being in close proximity to others involved. So at this point today, we are reasserting that Mr. Maloney poses no significant risk of harm to the community, poses no significant risk of harm of committing a felony, poses no significant risk of any harm to flight, and poses no significant harm to the administration of justice or intimidation of any witness. I don't know that it was stated before, but I want to be certain it's stated today that this is a good kid. And everything about his past is indicative of that, as well as everything about his present. Now, in terms of what brings us here today, there will be, or there has been, significant text messages and various other things and Instagram posts. But the facts at some point will reveal that Mr. Maloney had no knowledge of that person or the people involved, and that his culpability would be significantly less, if at all, and that will be established at trial. But in terms of establishing what makes him a good candidate for bond, this is his home. He was a 10th grade student at Frederick Douglass High School. His average at the time of his arrest was a B. It was an 80, so that would make it a B. After his arrest, I think the incident happened, I believe, in December of 2024.
Correct. Very end of December 2024 is when Mr. Van Arsdale was killed.
And Mr. Maloney was arrested in April of 2025. He was arrested, in fact, at school. He was pulled out of school. Now, subsequent to that.
So he wasn't hiding.
He was not hiding. He was not hiding. He was doing the things that he had already been doing, a student. And subsequent to that, even while incarcerated at Metro YDC or YDC, whatever the initials are, he's made all A's and he's made all B's. He has a stack of awards. He's even homecoming king. I didn't know that was a thing at YDC, but he's homecoming king. He has a stack of awards. He has a Pastor Brown, I hope I get the name correct, John, who tends to not speak highly of people, and he speaks very highly of him. He is someone that he has been asking for updates. He is someone that wants to be a part of his life as a mentor and as a person with whom Mr. Maloney would be attending church with on a regular basis. So again, I'm going to end. I've said enough, but I will say what I said earlier. He's a good kid. He's not going anywhere, and he looks forward to proving his innocence. And we ask that he be allowed to do that as a member of the community. And he is eligible for county paid monitoring as well, Your Honor.
Okay. You don't need to specify the address right now. You obviously need to provide it. I need to know the city it's in and with whom Mr. Maloney would be living. Just to say, hey, there's an okay space actually addresses none of my concerns other than the geographical one, but you haven't even told me it's in Lithonia or it's in, so I need to know the city it's in and whose place it is.
It is in Atlanta. It is approximately 20 minutes away by car from other prohibited people. It is with his sister, and I will provide that address to Ms. Singleton and to the court.
Okay.
there has been concern about it being expressed openly in court.
I'm not asking for that. It's with his sister. His sister is how old?
She is 27, Your Honor.
And who else lives in that household?
That I cannot say right now. She and their mom just left. The mom is a diabetic and she had to
Okay,
go get
they had to
food.
step outside.
Had to step outside.
Okay, that's something you're able to provide in an email, as long as that email goes to Mr. Abadi and Ms. Hicks.
Yes.
And to me and Ms. Nelson. I need to know who's in the household and where it is in Atlanta.
We'll have that before the day's over, Your Honor.
Okay, got it. Anything else?
And again, we're asking that a reasonable bond be granted somewhere in the neighborhood of $50,000, Your Honor, plus monitoring.
Right. Ms. Singleton, Mr. Maloney is still at a YDC?
No, Your Honor, he's in the jail.
He is
Now,
maxed out and is in the jail. Mr. Regis described glowingly what Mr. Maloney's stint was like at the YDC. That's what your information shows as well?
Yes, Your Honor, I have all the certificates, his high school transcript and his grades from Metro, as well as his discipline reports from high school. He had 2 fights when he was in high school.
Okay.
But he was very well liked. They are still asking me about him.
How he's doing?
How he's doing.
Yeah.
Is he gonna get a bond? Is, how's the case going? They're very concerned. Pastor John is actually the chaplain for Metro. And for Alberta's 17-year-old ago. And he texted me yesterday to find out if the hearing was still going today because he's eagerly, this is only the second juvenile that he's ever showed interest in this, to this level. And with the other case, he does mentor that young man is out and takes him to church and takes him to different activities and things of that nature. And he's eagerly hoping to have an opportunity to do it with him.
Okay, thank you.
Still will be under my supervision.
Got it. All right. Mr. Abadi, you don't need to, well, I don't remember a whole lot from what you shared because it was many months ago, but you have been helpful in explaining your theory of each defendant's connection to, I do remember the scheme involving getting Mr. Van Arsdale there and what happened to him. But if you could put it into context and give me your thoughts about bond.
Yes, Your Honor, as it relates to this case, back up on, we would hold the same position that Mr. Maloney is not a good candidate for bond, based on the same factors that Your Honor denied on. I think it was on September 8th or 18th, 2025, where you said he posed a significant risk of danger to the community, as well as a risk of committing felonies pending trial, and that he was at risk of further administration of justice as it related to the Ayala factors. What I can tell the court about the alleged role of Mr. Maloney is that based on statements made by other actors in the sequence of events, is that he was somebody who not only walked up to the vehicle that the victim, Mr. Van Arsdale, was in, but actually was one of the shooters who actually shot into the vehicle.
Talk about it.
I know at the previous bond hearing, the address for the defendant was 718, I think, Osborne Road, which was almost next door, very close to where the incident occurred. So I understand that was one of your concerns, as well as the fact after this all occurred, Mr. Maloney, as defense counsel has raised or brought before the attention, was involved before with a bunch of Instagram DMs or messages. But afterwards, he also had a series of posts and messages, and one of them being a bag of shelter saying, this is how you don't get caught. And that was after the murder. And there's evidence that there was an attempt to collect shell cases based on the videos that the state was able to obtain, Your Honor. So based upon all of that, state would contend for the no change in circumstances since your prior denial of bond would request that he remain in the custody of the Fulton County Sheriff's Department.
All right. And as the movement, Mr. Regis, anything you want to say in response?
Just very, very briefly, and as much as I truly respect Mr. Body, and I know he indicated that other actors have said things that are different, and I don't know that other actors has as much as an actor has, and that an actor will be challenged rather vigorously at the appropriate time. Now, also, I did want to add that Mr. Maloney has zero criminal history. He's unlike many. He has zero criminal history. So as far as him being a significant risk to re-offend, well, as of yet, he hasn't offended in terms of there being a conviction. So again, I promise to be brief, and I'll honor that promise by again saying this is a good kid who would be out with a supportive family, and they will ensure that he does the things that he's required to do, and he will be here at all court appearances, Your Honor.
Got it. If you would please get that information that I asked for, the address and the occupants, then I'll have all the pieces I need to work through this a second time.
All right, thank you, Your Honor.
I apologize. I know Mr. Vegas is a movement. I forgot to bring to the court's attention. You know, I did check the family. There are several members of the Van Arsdale family who were present. They may want to address the court briefly.
Okay, and I made the same mistake. They are always here and they always have a right to be heard, and that never changes. So if you would come on up and stand, well, actually, because our court reporter is virtual, if you'd sit right there, and I'm going to get that camera on. Good morning.
Good morning.
Remind me your connection to Mr. Van Arsdale.
Make sure the microphone is on, please.
Hold on.
Oh. Oh, my name is Lauren Van Arsdale. I'm the oldest sister of Monty Van Arsdale.
Okay, thank you again for being here.
Thank you.
So many times. Tell me what you'd like to tell me.
Of course, I would like bond to be denied. I keep hearing all this about a good kid and this and that, which is great and all, but I don't really see how a good kid gets caught up in a murder, especially right after the holidays. I would think a good kid would be at home with his people, being a good kid. Also, there doesn't really seem to be no level of remorse for you to pick up shell casings and then post about it. I think that somebody who doesn't show no level of remorse is a threat to the community. Sorry, 1 second.
No, take your time. You're doing great.
Also, as far as where he will be living, I don't think 20 minutes is that far from the place of where it happened. From my knowledge, his house was where the boys ran into. So for you to say you had no knowledge of the plan, but your house was the getaway house per se, doesn't really make sense to me. Also, in my opinion, like I said, 20 minutes is not that far. If the guidance of his parents wasn't enough to keep him out of a murder, I don't see how the guidance of a 27-year-old older sister is going to be any different. Also, like I said, I think it is very important who else is in the house. And also what is going to be her presence, you know, as far as support and guidance. Does she work? Is she going to be at the house present to see him most of the time? But yes, sir, I do believe that bond should be denied.
Okay. Thank you for being here and for sharing that. I appreciate that. I want to remind you and the family, everyone who's here to support Mr. Van Arsdale, you are bringing up some excellent points. They're points that I don't expect Mr. Regis to say, well, but think about this, Judge, because you're processing information as you hear it, and Mr. Regis's perspective is the state has a burden of proving all those things. And so they may well be true, and that may be the proof at trial. I need to continue to operate with the legal presumption that Mr. Maloney hasn't done anything until it's proven. That doesn't mean I'm not concerned about all these things. It's all real. Most real of all is Mr. Van Arsdale is dead and someone shot or multiple people shot and killed him. So no one's forgetting that. But I didn't want you all to think because no one responds to the things you just described. Oh, well, didn't you hear what I said? Everyone heard what you said, and it was important to hear. This just isn't the forum where, well, you know, it's more complicated than that, and that's not what the evidence was, or that is what the evidence was. It's what you've been dealing with, and that's what I need to hear. So thank you.
Thank you, sir.
You're welcome. Okay. No, that's all right. I'll still end with you, Mr. Regis, if there's anything else.
And I have great respect for the words of the family, and I understand all of that, what she said, and I understand how she felt, but I'm going to leave the court with what I left it with previously. while maintaining a great deal of respect and sympathy for her.
Got it. Okay, and that's what you need to do. Mr. Maloney, I will sort this out and something will be entered into the docket and your lawyer will let you know what that is, okay?
All right, yes, sir.
Oh, and you didn't hear this before, but we do have a trial date, which is August 6th. And is it your sense, not a firm commitment, but your sense, Mr. Abadi, that Mr. Maloney would be one of the cases that would be in the first group? No. Okay, then August 6th isn't going to be your date. But that means we are starting to move the case along. And that's progress for everyone. Because however that trial goes is going to shape a lot of things. If everyone is acquitted, the state's going to look at it differently. If everyone is convicted, the defendants are going to look at things differently. So we'll keep moving it forward. Thank you. Thank you, Mr. Regis. You gave us a whole morning. I'm sure you need to be in a bunch of other spots. All right.
Have excuse.
You may. That was the thank you part. And thank you, Ms. Singleton, for being here. We have one more bond here. It doesn't involve you all or conversation. 1:30. We're not starting at 1. We're starting at 1:30. Okay? Yeah. Mr. Hoover, come on up. I know who you're here for. Yes. Yeah, I say come on up. Oh. But before we bring Mr. Clark out, I just want to have a conversation because Mr. Abadi had a different recollection and I don't want to mislead Mr. Clark by bringing him out here. Mr. Abadi, you weren't here. Ms. Ocom was doing a good job of backfilling for you and Ms. Hicks. But what Mr. Hoover reminded me of, and it had a glimmer of recollection of it, was that when we were last together to argue about severance and some other things, I may have said, well, we can talk about bond again if something has changed. And Mr. Hoover says something has changed. So I don't know what that is, but here we are.
And in fact, Your Honor said that during the bond hearing that if something he bring it to court, then I didn't remember receiving a motion as it related to this something that changed, put everyone on notice that something had changed. So
Okay. Well, why don't you tell both of us before we're not bringing anyone out yet, because it may be that we need to do this next week or when you're next available so that the state is in a position to respond.
Yes, Your Honor. So the issue, I wouldn't say the issue, but the thing that held everything up last time, from what I remember, was Mr. Clark's actual where he would stay once he, or if he gets a bond, he's released. Because if you remember, Mr. Clark was arrested in another state because he was actually living with his father, going to school in another state. He was here visiting his mother during Christmas. And the issue was
the incident, which is December 29th, 24, no one's disputing that Mr. Clark was in town. He was in town visiting his mother. Correct. But home was out of state, not a flight location. That's just where he was.
Yes.
And he also was arrested in school?
He was arrested in school, out of state.
Just
yes,
where his school was.
Exactly. And it took 2 months to get him actually back here once he was arrested.
Yeah.
We have finalized exactly where he will stay here in Georgia, outside of where the incident happened, but here in Georgia with family. We've got the employment situation. We're almost hammered that's almost hammered down. But where he's going to stay, who he's going to stay with, has now been taken care of.
Okay. Mr. Abadi, my thought is we bring Mr. Clark out so Mr. Hoover can get onto the record all these things. And I'm going to ask you, with Mr. Clark out here, if Mr. Clark's going to be in round 1 of the trial, and then I can take all that under advisement and decide if I think I'm going to change his setting. You all right with that?
Yeah.
Great. Ms. Morgans, your group needs to leave when?
12:20.
We're aligned. This shouldn't take too long, and then we'll have a chance for a brief convo because I need to leave at the same time. Mr. Clark, we got you back out here as promised. We're going to get on the record in your case. It's 25 SC 006076, and we are having an additional conversation about bond for you. When we spoke before, I was working through some of my concerns about home for you was actually out of state. I wasn't comfortable having you be on bond, maybe at all, but if you were going to be on bond, I didn't think it should be out of state, but that's where your dad lived, that's where you were going to school. And so Mr. Hoover had some homework, which was to work with your family to figure out, is there a different scenario where you could be on bond and be living in a place safe for you, safe to keep you away from co-defendants, et cetera, that would be in Georgia. And Mr. Hoover is going to talk to me about that. I may have a few questions. I'll certainly hear from the state. And I may hear from Mr. Van Arsdale's sister or some other family member, because they're entitled to be heard anytime we're talking about bond for anyone who is named in the counts that involve their family member. And you're one of those defendants. Mr. Hoover.
Thank you, Your Honor. So the last time we were here, the biggest issue that was still outstanding is where would Mr. Clark be if he was granted bond? As you said, you gave us some homework, and my team, especially my investigator, has actually done that homework, put in the work. And right now, Your Honor, we can tell you that Mr. Clark's family is here. They're in the second row. He would be staying, if he's allowed bond, he would be staying at 8121 Creekstone Court, Riverdale, Georgia, 30274. Staying at that residence is the grandmother who was the homeowner. Her name is Charlene Harrison. We have contact information for Ms. Harrison. Speak to her often, and again, she's here. Jerome Clark II, Mr. Clark's father, actually moved back to Georgia, and he will be living in that residence as well as Mr. Clark's aunt, Patrice Tolbert. We have contact information for both of them. We're in constant contact with them. Mr. Clark's mother actually lives in Atlanta as well. She doesn't live at the residence, but she's another person that's going to be able to create stability for him while he's here. Also, Your Honor, that is in Clayton County. It's not in near the area at all where the shooting happened. He won't be around anyone that's involved in the case. He won't be around the victim's family. And it gives him an opportunity to get out and get back to get his GED so he can actually finish high school. On top of that, Your Honor, we did, like you said, Mr. Clark was working at Five Guys when he was out before this incident happened. My investigator did
Five Guys in Tennessee.
Yes. So my investigator, I gave him a little extra homework of where we could actually get him
bonus
employed. And we have spoken to Five Guys in Riverdale. My investigators also spoken to within 2 miles of the residence. It will be McDonald's, Pizza Hut, Shark's Kitchen, and a BP gas station. There's also an IHOP, Waffle House, and Zaxby's. We've spoken to managers of all of those places, and they have openings. They are looking for people to hire. My job now is that when Mr. Clark gets out to actually go speak with the manager, let them know the situation to get him in. But not only do we have a stable residence where there will always be someone there with Mr. Clark, we also have the opportunity for him to get employment and the opportunity for him to get his GED while he's out, while we're taking care of all of this. And in regards to the August case, again, my entire month of August will be in Carroll County. Actually, Judge Hightower is going to be giving you a call very soon about that. So I know Mr. Clark will not be in the first batch. It will be the end of the year before he is. And again, I don't want to harp on it too much, but in this case, Mr. Clark was named as one of the people involved. Again, because Mr. Byrd was arrested, one of the co-defendants who was arrested he's literally one of the ones that's charged with almost everything in the indictment. When Mr. Byrd was arrested and he comes in, he literally spent hours saying, oh, that wasn't me, that was this person, that was this person, that was this person. There aren't the text messages, there aren't group chats, there aren't pictures, there aren't videos. Mr. Clark is not involved in any of that. And I understand that the state has told the media and the family at this point is what they believe they can prove, but I want to make sure it's clear. Mr. Clark is here because Mr. Byrd, who is tied into everything, has literally said, this person did this, it wasn't me. This person did this, it wasn't me. And to give the court an understanding, every time Mr. Byrd said something like that, it was, okay, so am I good to go now? Can I go home now? Can I leave now? He's literally distancing himself and naming other people that he's bringing into the situation. So there's a lot that we're going to have to litigate and argue in this case, but I want to make sure it's clear. Mr. Clark is not involved in the messages. He's not involved in group chats. He's not involved in videos. He's not involved in pictures. This is literally because the person who is involved the most out of everyone else has been pointing at as many people as possible to say he's not the one that did everything. It was everyone else. So with all of that, Your Honor, and there's no way we're going to go into August with Mr. Clark. I ask that we get him in a stable position. His family is 100% okay with ankle monitoring. He understands he's going to have a curfew. There's going to be a strict regimen that he's going to have to abide by, but at least let's get him out, get him done with school, get him into employment, and get him out of the jail while we're figuring everything out.
All right,
Thank
that
you.
all makes sense. And which one is Grandma? Thank you for being here. And you confirmed that that address in Riverdale is where your grandson could stay?
Alright.
Okay, and if there's a curfew, there's a curfew, even though that means he's gonna be up in your business. You're all right with that? Okay, thank you. Mr. Abadi?
Yes, Your Honor, the state's position remains the same as it relates to Mr. Clark, that we would respectfully request the court deny the request for bond. I didn't hear any change in circumstances or any circumstances related to, or any circumstance that has changed related to Your Honor's finding, which was that not only that he posed a significant risk of flight, but posed significant danger to the community and the people within it. So I didn't hear anything as it related to that prong that Your Honor determined at the April 9th, so about a month ago, bond hearing. I would also, just in response to Mr. Hoover's recitation of facts and things of that nature, he is 100% spot on correct about Mr. Byrd, but then they were able to corroborate a lot of the things that Mr. Byrd said via phone records, and there are messages that involve Mr. Clark. So I won't get into the full factual circumstances because it's not relevant as it relates to bond. But
there's not something as much zing as here's how you don't get caught with a bag of shell casings in your hand.
Not have that.
Because you would have said that.
Yeah.
Okay.
So.
All right.
And I,
But as I presumed, but again, we're not proving or disproving the case there. If all it was Mr. Byrd saying Clark was involved, you wouldn't have necessarily pushed this case as far as you have as to that defendant.
That's correct.
Okay.
And then I don't know if anyone from the family, I don't know if his sister or any of his parents would like to say.
So she's going to speak again. Don't react to anything. She's going to miss the sister.
Good afternoon. My name is Elisa Van Arsdale, and I'm the mother of Monty Van Arsdale. He's my only son. I'm 19 years old, and he was gunned down and murdered in the vicinity of where this young man resided at the time. I'm not sure, the court is wanting a different address. I don't know, help me understand how a different address is going to alleviate or rectify involvement in gangs. I mean, you still have phones and texts and computers and visits. I mean, just being in a different location doesn't change a mentality. It doesn't change actions that took place. I'm not sure. I know that they are saying that Tennessee was somewhere he lived before. I'm not 100% sure if that's accurate. I mean, because at the time of the investigation, it was told to me that he was unenrolled out of school at Douglas High on December 31st, which would have been day after my son died. So, and also him being in Tennessee, it was a time he got arrested, I believe, March, didn't maybe get back here till maybe because he refused to come back. So there had to be some red tape they had to go through in order to get him back here. So I just want to go on record that I do feel that he is a threat to the community. This happened within his community. So how more are you going to protect another community and you didn't protect or care about where you yourself lived? I understand there may not be priors, but it's unfortunate that his criminal history started with murder. And I object for him to be able to get bond. My son is in a state of ever resting eternal, and he doesn't have the opportunity to be here and be seen and advocate and be the opportunities that he's getting about a GED and this and that. But murder is very serious. It's not we can't get a redo. I mean, and this has caused devastation to me, to my family. It's been heartbreaking. It's numbing. And it's broken my heart.
Right.
So I just want to go on record and say I definitely oppose. Okay.
All right. Thank you for being here.
Thank you.
You're back.
Yes, I am. Do I have to reintroduce myself?
You know who you are.
Okay.
Mr. Van Arsdale's sister.
Oldest sister.
Oldest sister, not just any sister, the oldest sister.
Yes, sir. So of course, just like the last co-defendant, I mean, I think bond should be denied. I think last time I didn't even really speak on my brother, but my brother was a good kid. He had just graduated high school. He was finding his way, like I'm sure a lot of these boys are. Yet he wasn't finding his way by being involved in a murder. So while you've done good up until this point, like my mom said, I don't really see how your first offense is something of this degree. And the fact that the defendant did not even know my brother, I think that comes to a threat to the community. If you can hurt somebody that you don't even know, what can you do to people that you do know? I think a major thing here is stability. A major topic of conversation is stability. And yet I haven't heard any. I heard the grandma lives here, the dad lives in Tennessee, so-and-so lives here. He unenrolled from school here, went to Tennessee. So it's just no really sense of stability to me. And yes, I do think that bond should be denied. Yes. That's it.
Okay, thank you. Mr. Hoover, anything in conclusion?
Yes, Your Honor. And just quickly, to address what the state said, that they don't see a difference because the issue of maybe this Mr. Clark will have flight or maybe he's a danger to the community. Well, there is a difference because now I'm giving you, at the beginning when we had our last hearing, we didn't have an actual address. We didn't have actual people that are going to live there. I'm giving you the actual reason why there won't be an issue of flight. I'm giving you an actual reason why there won't be a danger to the community. He will not be in the community. He will be away from the community with family. We're going to get him enrolled to get his GED, and we're going to get him employment. So those are 100% reasons why the issue of flight is no longer an issue, and the issue of danger is no longer an issue to the community. And the state didn't give you any examples of how it could be still an issue. They just said, well, nothing's changed. That's fundamentally not true. Something has changed. Number two, when it comes to, I completely understand what the family is going through. I've been in front of you in bond hearings like this before, and I have to stress that I fundamentally disagree with the state telling the family that Mr. Clark is involved with messages and communications about this murder. I have to stress, I fundamentally disagree. If that were true, Your Honor, we know the state would be up here and they would tell you, well, these are the types of conversations that were had, because they told you in the last young man, well, these are the pictures that we saw with shell casing. The state didn't do that because what I believe is what they're telling the state is not specifically for Mr. Clark, but it's for everybody. And they're grouping Mr. Clark in. Mr. Clark is not part of any of the conversations of a setup. He's not part of any of the conversations of a shooting, a robbery, a drug deal, anything like that. I fundamentally disagree. I understand why the family feels that way, but it's because the state has been telling them that, the officers have been telling them that, and that is not true. And that will come out when we go to trial. But as of right now, as you said before, Mr. Clark is presumed innocent as of right now. And the state hasn't presented you anything of how he will be a flight risk. The state hasn't presented you anything else of how he'll be a danger to the community. And what he has been, not he, but I know it's not Adam, but what the state has been telling the family is fundamentally not true when it comes to Mr. Clark. And for those reasons, we are asking for a $50,000 bond so we can get him back into another community, but get him out so he can get back into his school, get back into work, and his family will make sure that he shows up to every court date from here on out.
All right. Thank you, Mr. Hoover. Mr. Abadi, is it your expectation, again, not a binding announcement on your part, that Mr. Clark, it doesn't matter what you'd expect because Mr. Hoover is not available. If August 6th is a go live for a trial of some of these defendants, we couldn't do Mr. Clark because Mr. Hoover has the month-long Carroll County trial.
So that was the reason I'd made the decision I made based on his prior announcement.
Got it. And so that's why Mr. Maloney was told you wouldn't be going in the first round, because he'd be going with Mr. Clark, along with Mr. Byrd and Mr. Shamblas and Mr. Shannon, the folks who are linked to Mr. Van Arsdale's murder.
Correct, and that
Okay.
allows us to have fewer trials
Yep.
if we wait on Mr. Hoover.
Okay, got it. Thank you. That just helps me with planning and coordination. Mr. Clark, I will enter an order, and if it sets bond, Mr. Hoover will let you know all about all those details. It would have a dollar amount. Your family has to post that. If it denies bond, he'll let you know that as well, and we'll keep moving your case forward, all right? Okay.
And Judge, before you end for the day, this doesn't involve Mr. Clark, but since this is being actively recorded and anyone can go back and rewind and watch any of the things that are brought up currently as it relates to this matter. State made an offer to everyone who asked for an offer. Mr. Mitchell asked for an offer to be held off so he could review the discovery and provide me information if he'd like his client to make a profit. He's never contacted me since.
Okay.
As it relates to Ms. Warlick, an offer was related to her, it was life. And it was at the last hearing we had where she sat and did her motions. And at the end of it, she told the court and the state that she would be providing mitigation to me, Mr. Rabati. I haven't received a single email, phone call, text, letter, note, anything sticky saying I got the information. I want to make that very clear that it was not the state who prevented the final plea of being fully successful. It was defense counsel as it related to those two matters.
Okay. I was less concerned about Mr. Shannon, given the charges he faces. It was the Mr. Blackwell where I was confused, but I only had half the equation. And Ms. Ocom was parachuting in, and I respect that. She wasn't privy to what those exchanges had been. And so it's just, it led to a bumpy start because we just went through the defendants alphabetically. And so the very first one, and he says, I don't know. And that was one that I figured if anyone was going to be sorting stuff out, maybe Blackwell, maybe Miles Pratt. And he didn't, Mr. Sharp didn't say otherwise. He just said, Mr. Abadi and Mr. Hiles and I had talked about things one way, and I'm a little confused about the direction it's turned. And I said, we'll get everyone together and sort that out.
And so it's clear we have set up a time that me and Mr. Sharp and his client will be all sitting around the table together.
Okay, sounds good. Mr. Hoover, anything else?
Nothing further. May I be excused?
Not almost. Your Carroll County case.
Yes.
It's not something that if you just think a little harder, it's going to be resolved. It's a trial.
No, it's a 100% trial. I just gave the state and the judge the jury questionnaire. It's about to go out to about 500 jury. Yeah.
Okay, it's that real.
Oh, yes.
Okay, we will stay out of your way.
We are looking for hotel accommodations now.
Okay, well, good luck.
Thank you, Judge.
All right, ladies and gentlemen, we are going to be in recess until 1:30. I know, I'll get to it.
Judge, can I have excused?
Yes, sir, thank you. Are you needing to come back at 1:30?
I think I'll come back for Rashad.
No, Your Honor, I'll be covering that. I'll be covering at 1:30.
All right, thank you, ma'am.
Somebody will be here.
Okay. All right, we'll see you guys at 1:30.
5, 10 years. So this point, no matter what you buy it, you know what I'm saying? Because if you don't think it's gonna be worth more than it is in 5, 10 years, then you shouldn't buy it. Oh.
Bro, you done cut your hair out, bro. We were locked up together, bro, at Rice Street.
What the hell your name is?
Please mute your devices, please.
Oh,
Aaliyah, can you hear me? Okay, you can hear me. I can't hear you. Let me try and fix that part. Okay, can you say something else?
He's got the podium.
I got it. I can hear you guys now. Okay. You know, I never have good working Zoom, so I wanted to make sure it actually worked before I came or before I stayed in my office.
All right. We are back on, and I think people should be able to hear us. Let me grab this afternoon's calendar. That's this morning. It's Miss Clark. Last minute. Here it is. All right. So position, we've got a final plea calendar, and I think most of the cases, oh, they're going to different places. Let's just get started. Ms. Johnson, is she here?
Yes, John.
Hey, Mr. Hardwick, how are you?
Good afternoon, sir.
So we're on for final plea. So either we've worked things out, and if we haven't, we'll go into a trial calendar, and Ms. Johnson's on our mid-June trial calendar. Have you and Ms. Smith worked things out?
We have, yeah.
So a plea.
Yes, we've got the paperwork here to present to the court.
Great. We'll do that in just a minute. Let me see what is happening with the rest of the cases. We'll go from there. Positions 2, 3, and 4 are all Mr. Fagan, and that's Ms. Cabrera's case. And Ms. Cabrera, you need a breakout with your client, Mr. Fagan. Is he the gentleman who's at Riverbend?
Their mic is off.
Yep, they're turning it on. Hey, are you Mr. Fagan?
Yes.
Great. Mr. Fagan, I'm going to put you in a breakout room with Ms. Cabrera. Let me get you guys first on the screen so you can see each other. So there's Ms. Cabrera. There is Mr. Fagan. I'll put you guys into a private space so you can talk about your 3 cases. You've got 3 cases with me, but you are dealing with something else if you are in Georgia Department of Corrections custody. So it may be you can sort all this stuff out, but you and Ms. Cabrera need to talk about it, because if you don't, you are on the end of May calendar, which would mean we got to bring you all the way back to Fulton and figure out which case the state is going to try. But I don't want to get out ahead of things. I'm going to ask you to have a conversation with Ms. Cabrera, and then when you're done talking, you'll pop back in this space and we'll figure out the plan, okay?
Sir.
All right, let me see if I can make this work. So that is Ms. Cabrera and Riverbend. All right, should work. Let me know if it doesn't. Done. So we'll come back to that. Kayla Newborn is positions. Oop, I skipped one. Christian Falconer. Mr. Falconer is on the screen.
Good afternoon, Judge. Richard Blevins from Mr. Falconer.
Hey, Mr. Blevins, how are you doing?
Doing well, sir.
All right, I see you. I see your client. What are we doing today? Are we just talking about what the offer was and saying no thank you, or are we resolving the case?
We're not resolving it, Judge. I did get the offer. This is a case where I came in on mid-April, received all the discovery. It's pretty voluminous. I'm plowing through it. There's a lot of phone records and videos. It's a lot of extra stuff with it. So I'm not quite ready to say ready. I didn't know if the court would allow us to at least go to the next trial calendar. I should be ready by then. I do anticipate some motions being filed, Judge.
Okay, give me an example of a motion that you'd be filing.
Sure, Judge. There's a previous incident at a diamond store where an officer said that my client, he was a victim of it / witness, and they're saying he's actually a participant, but he hasn't been charged with it. So I would file a motion in limine for that, which probably could be heard right before trial.
Right.
There's a interview with my client. I haven't gotten to that part yet. I'm going through the phone records that I would probably do a Jackson Deno on, which I would imagine we could do before trial.
Okay.
The other motion would be one officer said my client looked like one of the suspects, but I would want to at least file a motion to limit on that and voir dire him before that's brought to a jury's attention to see how he based that. In mask and tactical gear, and I couldn't see a face on the videos I saw. So those are the ones that just came up right now, Judge, as I went through it, and a motion to suppress the search of his vehicle.
Okay. Well, that's a lot. And at least one of those, if it's suppressing the search, we'd need to have that evidentiary here. Was there something of value, Ms. Smith, found inside Mr. Falconer's vehicle?
I don't believe so, but the officers just did a lot of investigation on this case, so that's why we have so much discovery. But
Okay.
at the moment, I don't think it's
Nothing's jumping out at you that you'd be even trying to admit at trial. So it may be, we wouldn't need to go through that motion.
And I just point out, Judge, what it is, and maybe Ms. Smith, just to maybe refresh your recollection on it. They found a tactical vest and a tactical belt. I'm sorry, a vest, like a bulletproof vest and a tactical belt. And these are what the suspects were wearing as well.
Got it. And so they might want us, the state might want to say, look, the description was the robbers were wearing tactical vests, and look what Mr. Falconer has in his car.
Yes, sir. But if Ms. Smith wants to keep that out, I'll consent.
Okay. I'm not making anyone commit to that right now. And you are new to the case. And we actually had talked about that briefly when we took the plea in your other case a couple weeks ago. Let me make sure I'm following your request. Right now, Mr. Falconer's case, along with Ms. Newborn, co-defendants, their case is on the May 28th trial calendar. Now, that's the day that we call the calendar. It's not when it starts. It would start on June 1, so a month from now, practically. So I'm wondering, Mr. Blevins, given your schedule, I know you have other cases, if we preserve Mr. Falconer's final plea rights and say, let's see everyone on the 28th, so 20 days from now, and if it works out, that's great, it can work out. If it is going to be a trial, that's a week, the week of June 1, by which you'd be ready for trial. Is that what you were saying, or were you saying, dang, I'd like it to be deeper into June?
I would like to say, dang, I'd like to go any deeper in June, but I could be ready by June 1, Judge. I think that's, I mean, I'm pretty much gone through it all. I just need to make sure I didn't miss anything and go over a few minutes. So.
Well, here's my thought. Let's, for now, keep Mr. Falconer's case on, along with Ms. Newborn's, for that May 28th call of calendar, June 1 start of trial. And if between now and then, either you file some evidentiary motions where we have to have a hearing, I got a rule on that, that might be reason enough to bump it to the end of June. But it also may be, as you and Ms. Smith talk about it more, that some of the motions you were thinking of filing would be moot because of the way the state's approaching the case. So I'd like to keep the focus on getting the case ready to go. This is an incident that happened back in it's now 2 years old, the incident. So it would be good to keep it moving as long as that's not disadvantaging Mr. Falconer because you haven't had enough time, Mr. Blevins. But I'm hearing you say, hey, stretch goal. Let's see if we can all be ready for the 28th.
Fair enough, Judge.
Okay. Mr. Falconer, do you have any questions about what we just discussed?
No, sir. No, Judge.
All right. Let me look something up here. All right, I was just checking your bond, Mr. Falconer. You're just supposed to stay away from the incident location, and that's about it, and one individual. Are you having any issues with bond?
None, Your Honor.
Okay, then we will see you on the 28th at the latest. And maybe before, if Mr. Blevins files some kind of motion that we need to have a hearing on and have everyone present. Ms. Smith, anything you want to add in connection with Mr. Falconer's case?
Not at the moment.
Okay. All right. Well, Mr. Blevins, certainly reach out to Ms. Smith if there's something you feel like you're missing. When should I be expecting that you would file motions so that we know if we need to schedule anything?
Judge, definitely by May 22nd, which is the Friday before the Thursday.
Okay. Well, we'll view that as, go ahead.
I said hopefully sooner, Judge, but that'd be my deadline I'll set for myself.
Okay, sounds good. All right, well, thank you both. You are free to go.
All right, thank you, Judge.
Thank you, Your Honor.
You're welcome. Co-defendant is Kayla Newborn.
Good afternoon, Judge. We would just ask to preserve her final plea rights until the May 28th calendar to kind of see where we are with the co-defendant.
Just same thing that we discussed with Mr. Blevins and his client?
Yes, Judge.
Okay. You're Ms. Golding?
Yes, Judge.
How are you doing?
Good.
I'm all right, which makes you Ms. Newborn. All right. That makes perfect sense. I wouldn't expect you to be put out of sync with how they're handling it. And the little hiccup was just occasioned by the fact that Mr. Falconer got a new lawyer. And so he's needing a little bit of time to get up to speed. But Ms. Golding, have you been on the case the whole time?
Yes.
So you're ready. You just want it to move at the same cycle as Mr. Falconer's case.
Yes. Yes, Judge, in a way, my understanding of the case, and Ms. Smith and I have been talking about it, is that perhaps something that the co-defendant is going to proffer or maybe not proffer would resolve Ms. Newborn's case, but that would obviously depend on his counsel and how they go forward with their case.
Got it. Okay. No, I'm reading between the lines on that one. But if that doesn't come to pass, you've got all the discovery, because the other thing I do during final plea is make sure there are no discovery issues. You've got all the discovery, and other than holding out a hope that maybe this isn't a case for Ms. Newborn anymore, you're ready to go. If what we figure out on the 28th is Mr. Blevins is ready, Mr. Falconer is not resolving his case, he wants to go to trial, you'd be ready as well.
Yes, Judge.
Okay. All right. Then I'll preserve Ms. Newborn's final plea rights, and we'll see everyone at the call of the calendar if things haven't been sorted out before then. And Ms. Newborn, I'm just going to take a quick look at your bond, make sure I know what it is you're supposed to be doing. So you got a bond a long time ago also. And you had filed a discovery deficiency notice at one point. That's been addressed?
Yes, Judge.
Great.
I received all the discovery.
Okay. Your bond is funny looking. Okay. Nope. You're supposed to stay away from this Mr. Ferry person also, and that's it. Okay. Do you have any questions, Ms. Newborn, about what's going on? Okay. Anything else, Ms. Golding? Ms. Smith?
Nothing further, thank you.
All right. I'll see everyone on the 28th.
Thank you, Judge.
We handle 7 and 8. Ms. Wood, Ms. Nelson tells me that Mr. Alexander is a plea. Is that correct?
That's correct, Judge. We are ready when the court is ready for us.
Excellent. We'll get to that shortly. And then Mr. Foster's been dealt with. So I think what we've got left is an update on Fagan, a plea with Ms. Johnson, and a plea with Mr. Alexander. And I'm just going to go in the order of the calendar, which would mean we do Ms. Johnson, if that's ready to go. And then we'll take care of Mr. Alexander. So Ms. Johnson, if you and Mr. Hardwick would come on up to the podium. You good?
Yes.
If you guys would switch positions. Court reporter needs to be able to see Ms. Johnson. It's easier to make sure she's getting down what she needs to take down. You ready, Ms. Smith?
Yes.
Okay, this is 24 SC 000-602, State versus Johnson. Ms. Johnson is here with her lawyer and Ms. Smith is here for the state. Ms. Johnson, you ready to go forward?
Yes, Your Honor.
Okay, the way this works is that Ms. Smith will be putting you under oath in just a moment and then asking you questions about your case and about your rights. You need to answer all those questions truthfully. You also need to let Mr. Hardwick or me know if you've got any questions. If someone says something that doesn't make sense or you don't understand, or you just got a question about something, you need to make sure you let us know that. Will you do so?
Yes, Judge.
Great. Ms. Smith?
Yes, Judge. Before starting, would you like to know about the reductions in this case?
Yes, so you ask every time, you should just tell me in the future. If there are reductions, say, Judge, before we start, here's what we're doing for Ms. Johnson.
All right, well, Judge, before we start, here's what we're doing for Ms. Johnson in this case. For count one, we're gonna reduce that charge to simple assault. That is OCGA 16-520. For count three, that would be a no cross.
So count two stays the same and count three goes away. Excellent, got it. So this is a misdemeanor plea.
It is. Ms. Johnson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Raina Lonice Johnson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone to school?
I am a PhD student and I am 43 years old.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with his services?
Yes.
Counsel, are you satisfied that your client has an understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I do.
Ms. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Your Honor, I might say here that what we intend to propose for the court's consideration is a nolo contendere plea. I know that counsel is referencing what is reflected in the forms that we signed off on, but I made a correction on there. So I just wanted to state that for the record.
Okay. Ms. Smith, do you have any issue with this being a nolo plea?
No.
Okay.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
I am. Yes.
Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this plea today?
No.
As to indictment number 24 SC 000602, how do you plead to count 1, reduced charge of simple assault, and count 2, battery?
Nolo.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from this guilty plea? But
Yes.
if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Johnson. Your Honor, if this case were to proceed to trial, the facts would show that on May 18th, 2022, officers of the South Fulton Police Department responded to 6015 Landmark Way in reference to a domestic physical altercation. When officers got there, they spoke with Ms. Pamela Nelson, the victim in this case, who stated that her her brother's girlfriend had just beat her with a rifle gun. The officer then asked Ms. Nelson what happened. Ms. Nelson told the officers that the two had been getting into verbal altercations lately for the past 2 weeks at that time, and that Ms. Johnson, the defendant in this case, was throwing Ms. Nelson's shoes and telling her to leave the residence since the defendant in this case shared that place with the victim's brother. Ms. Nelson advised that she attempted to stop Ms. Johnson from grabbing her hands. And once she grabbed Ms. Johnson's hands, Ms. Johnson began to physically hit her in the face. Ms. Nelson stated that after she hit her in the face, Ms. Nelson started walking down the stairs to try to leave the home. But at that time, the defendant grabbed a gun and started to point it at Ms. Nelson, telling her to leave. Ms. Nelson said that while still walking down the stairs, she tried to leave the home, but then Ms. Johnson hit her in the face with the gun. She stated that Ms. Johnson told her, the victim stated that the defendant told her that if she came back to the residence that she would kill her. The officer then went back and she spoke. The officer did speak with the other officers on the scene, who decided to then charge the defendant in this case for the charges we have in front of us. Ms. Nelson at the time did have lacerations on her finger and by her ear that they could see she was possibly hit with something. When the EMS got on the scene to evaluate her, she did refuse to go to the hospital, but she was treated on scene. And that concluded the facts of this case we have in front of us. Regarding the negotiated plea between the state and the defense, we've agreed to, for count 1, a sentence of 12 months probation, and for count 2, 12 months probation to run consecutive, for a total of 24 months on probation. Regarding the special conditions of probation, we are asking for the defendant to stay away from the victim in this case, and also to complete an anger management course. I did get a chance to speak with the victim in this case multiple times. We talked about the reduction in this case, going from ag assault to simple assault. She was okay with it because of how long it has been since the incident happened, the fact that she hasn't had any run-ins with the defendant since, and just an overall outlook on what happened. The biggest thing for her is that she just does not want any contact with the defendant, but she was okay with the reductions in this case. She was given the Zoom link, but she said she has to work, so she was okay with me giving you her statements on how she felt in the case. But that is all from the state.
Got it. Thank you. Ms. Harvey, any criminal history information on Ms. Johnson?
She has 2 cycles out of Georgia, Your Honor, 1 out of Florida and 1 out of Louisiana. There does not appear to be any felony convictions, and nothing further.
What's the most recent cycle?
May 23rd, 2022, out of Florida. That was a fugitive arrest.
All right. Thank you.
And yes, Your Honor, you're welcome.
What the most recent Georgia one, is that this case?
It wasn't a phase to appear on this case from March 2nd. Yes, Your Honor.
Okay. Thank you.
You're welcome.
So, Mr. Hardwick, is the arrest in Florida related to this? Because it was like 2 days after this.
It is.
Okay. So Ms. Johnson retreated to Florida and was brought back here.
She was in the armed services, and that's what she was working out of.
Got it.
Yes.
Okay. I'm ready to hear from you.
Well, Yana, obviously, Ms. Smith and I have spoken a great deal about this matter. I have been representing this young lady since the inception of her arrest, appeared at the bond hearing that took place following her arrest. The significant thing that I want the court to also consider is that everything that Ms. Smith related is from the victim. There was a strong disagreement from our perspective as to the facts and how they sort of evolved. But we recognize that, as counsel stated, and apparently as the victim agreed, it's been 4 years. So we just want to move on. And I think that this is a fair way to do it. She does not have a record of any significance at all, save for this case. And we would respectfully request that the court accept the negotiated plea as proposed.
All right. Ms. Johnson, it sounds like at the time this happened, if I followed the facts correctly, you and Ms. Nelson's brother were in a relationship?
That's correct, Your Honor.
Got it. So your connection to Ms. Nelson would be, I'm dating your brother.
Yes, Your Honor.
And were the two of you, Mr. Nelson, would that be the right last?
Mr. Smith.
Mr. Smith, were you and Mr. Smith living together at the time?
We were.
So then Ms. Nelson came to live with you all?
Ms. Nelson lived there prior to me coming there.
So you joined them?
Yes.
Mr. Smith said, let's live together. You said, great. Oh, but by the way, my sister lives with us as well.
Yes, Your Honor.
Okay, got it. Okay. Do you know Ms. Smith, if Mr. Smith was present when all this happened?
I'm not too sure.
Because he could seem to kind of resolve. It sounds like there are two different versions of events, but if he was there, he could say there was a rifle, there wasn't a rifle, all that kind of stuff.
When I talked to the victim, she talks about the altercation them two had, but she never mentioned that my brother was there.
Okay.
For the court's edification, he was not present.
Okay. And there's nothing for me to resolve. It's a plea. I just always try to get a little more context to what was happening.
Sure.
All right. Ms. Johnson, you are getting your PhD in what field?
History.
That's exciting. Could be Dr. Johnson. How soon?
29.
Oh, okay. You got a ways to go. And where are you enrolled?
I'm at Clark Atlanta.
Okay. Super. Anything you want to add?
No, Your Honor.
You ready to be done?
Absolutely.
Okay. Are you and Mr. Smith still an item?
Item.
Well, do you and Mr. Smith, are you still dating?
We're friends.
You're friends, but it's a different nature of relationship.
Yes, Your Honor.
I might also add, for the court's desire to have a full picture, my client and Ms. Nelson have not interacted, spoken, seen one another in any way since the date of the incident, and she does not anticipate that that scenario will occur.
Well, that's why I asked about Mr. Smith, not because I'm prying into your business, but if you and Mr. Smith still spend time together, that puts you potentially in Ms. Nelson's orbit. That's the only reason I was asking. But if your relationship is less involved now, then you can go to dinner. You're just not going to be, if he and his sister still live together, that's not a place you can go.
Yes, Your Honor.
Okay, sounds like you understand that. Well, Ms. Johnson, if you don't have any questions about anything, then I'll accept your plea. I find there's a factual basis for it. That's not me saying it went down exactly as Ms. Smith said it did, but if Ms. Nelson were to come in to testify consistent with what she told the police, with the injuries she had, a jury could find you guilty of simple assault and of battery. So I can understand why you're pleading, NOLO, and I'll take that. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. You know what voluntary means. No one's forcing you to enter this plea. Do you agree with both those statements?
Yes, sir.
Okay. Mr. Hardwick, can someone in my office sign the indictment for you?
Sure.
Indicating the NOLO plea?
Sure, absolutely.
Ms. Smith? And Ms. Johnson, can we electronically sign your name indicating the NOLO plea to simple assault and to battery?
Yes, Your Honor.
We'll do that. I'm going to sentence you on count 1 to 8 months of probation and count 2 to 8 months of probation. Count 2 will run consecutive to count 1. So it's a total of 16 months probation. Special condition number 1, no contact with Ms. Nelson. Just maintain what you've been doing. Don't reach out in any way. And the only potential question mark is, insofar as you still spend time with Mr. Smith, you need to not have Ms. Nelson be a topic of conversation, because if he were to go back to his sister to say, let me tell you, Ms. Johnson wants me to deliver this message, that's you communicating with Ms. Nelson, and that needs to not happen.
Yes, Your Honor.
Okay. The other condition is that you complete an anger management course. Probation can help you identify one if you don't find one, but that's it. I don't think this is going to be a particularly heavy lift for you. Ms. Smith, anything else in Ms. Johnson's case?
Nothing further, thank you.
I'm trying to remember, there is a form that Ms. Johnson needs to fill out. She did already, excellent. To have, I need to verify another signature then as well. So you've already filled out what we call the JCS, Judicial Correction Services form. They will contact you. I don't know if it's an email or a phone call, but be responsive to that initial outreach, because that'll establish your connection with probation, and then you'll take it from there. You also completed a plea of guilty form with your lawyer, Mr. Hardwick. You initialed a bunch of things, and I need to confirm that on page 4, this is your signature. It kind of looks like your initials, but that's also your signature.
It's my signature, sir.
Okay. And Mr. Hardwick, you had a chance to discuss the items on the plea of guilty form with your client.
I did.
And you, in turn, on page 5, gave a very lawyerly signature. That's your signature?
It is. Yeah.
Okay, excellent.
I don't know if it's lawyerly, it's ugly.
Okay, but it's all there. I can see it. I think we've completed everything then. Anything else from you, Mr. Hardwick?
Nothing further, Judge. Thank you for, as always, being thorough, attentive, and understanding of this situation.
It's what I'm supposed to do. Ms. Johnson, good luck with the PhD. Stay on it. It's a few years, but it's quite an honor to get a doctorate. So I hope that works well, and you're at a great school.
Thank you.
What are you doing in the meantime? PhD doesn't put bread on the table.
I'm working, sir.
What are you doing?
Amazon.
Okay,
Logistics.
great. Well, they're a valuable employer in our community, so good luck with that. And the PhD, are you going to teach history once you get that degree, or what's the plan?
That's an option, teaching history.
Yeah.
I'm exploring other options.
Okay, well, good. Well, good luck with whatever it is you decide to do. Thank you very much.
Your Honor, Ms. Johnson has requested a copy of the documents that we signed off on. Is that doable?
Yes, the way you'll be able to get the plea of guilty form to Ms. Johnson is it will be e-filed. It'll be made part of the record, so you'll get it. You'll get a service copy.
Okay.
And you can forward that PDF to Ms. Johnson.
Okay.
The final disposition that I will sign, the 16 months, that also will get e-filed, so you'll get a service copy.
Okay.
The form for JCS, she's not gonna get a copy of that. That gets sent to
Not
JCS.
concerned about that.
Good.
Just the other two.
Yeah, the other two, you'll get service copies, and so you'll be able to forward those to Ms. Johnson.
Okay. Thank
Okay.
you, Judge.
You bet.
Okay.
Take care.
Thank you. Always good to see you.
Same. Ms. Cabrera. Did we lose her? She was on. Now she's gone. Ms. Nelson, if you could, she magically came back. Ms. Cabrera.
Yes, Judge.
It's like you could hear me, but you weren't even on the call. You popped back in.
Yes, I'm here. If I could get a brief breakout with him, I think we have a plea.
Okay. Let me do this. Mr. Fagan, did you hear that?
Yes.
All right. So Ms. Cabrera wants to talk with you one more time. I'm going to put you guys back in the breakout room. Did that work? You were able to see and hear her?
Yes, sir. Yes, sir.
Okay, then let me put you guys back in a breakout room and when you emerge, we can move on with that. Let's see. All right, Ms. Wood, are you ready with your plea with Mr. Alexander?
Yes, Judge, I see he is on the call.
Hey, Mr. Alexander, can you hear us?
Yes, I can hear y'all.
Okay, we're going to get started in 1 second. Let me find your case. You moved away, Ms. Smith. Someone else is handling this plea?
I thought we were going to do the Rashad Fagan's.
She's just too quick. Nope, we're going to do Mr. Alexander. So if that's your case, you can be right there because everything is virtual. If that's easier for you, I'll just switch the cameras around.
Okay, I can say that.
Okay, but first, Ms. Dennis, how are you? You qualify, so I'm going to sign the affidavit. Do you know where to take your paperwork?
Yes.
All right. Well, I hope this works out for you. You're welcome. 9 kids. That's a lot of kids. You would know far better than I. Okay. Some of them are still with you, though. Okay. Do they help you take care of things, or you have to take care of them? Both. That's what kids are like. All right. Thank you for your patience. Make sure I checked everything for you. There you go. Good luck. All right. Let's get Ms. Smith on the screen. Okay. So we're going to get on the record, Mr. Alexander, in your case, it's 26 SC followed by 4 zeros and then 52. You're charged with, right now, aggravated assault and cruelty to children in the 3rd degree. Mr. Alexander, are you ready to go forward with your plea?
Yes.
I need to clear 2 things up with you before we can start. One, you have a right to be here in court, but you are appearing virtually. Are you waiving your right to be here in open court?
Yes.
You also have a right to have Ms. Wood next to you, so you could turn to her with a question or seek her advice. You're still able to do that, but it would be a little indirect. I'd have to put you guys in a breakout room. But Ms. Wood is going to be operating from her base and you're going to be operating from your tree-lined street. You okay with that?
Yes.
Okay, then that's how we're going to do it. Mr. Alexander, in a moment, Ms. Smith will put you under oath and start asking you a bunch of questions about you and your case and your rights. I need you to answer those questions truthfully. Please let me know if at any point you can't hear us because of the connection you've got or if you've got questions about things. Will you do that?
Yes, sir.
All right, Ms. Smith?
Yes, Judge. Before we start, count 1 ag assault in this case will be reduced to simple assault. That is OCGA 16520. Count 2 will remain the same.
Understood. Thank you for that.
No problem. Mr. Alexander, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Markevian Latoria Alexander.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I am 26 and I had started school at Atlanta Technical. I graduated high school though.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Alexander, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No. Or I don't have any.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation?
Yes.
Do you also understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing?
Yes.
And this is also including on a federal case.
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you also understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you
I
understand that?
understand.
Okay.
I understand.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Alexander, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 26 SC 000052, how do you plead to count 1, the reduced charge of simple assault, and count 2, cruelty to children in the 3rd degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea? But if you believe that there's some type of error in your guilty plea, that you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, I understand.
Do you also understand that has to be completed, that process, within 30 days from today?
I understand.
Do you also understand that you have only 12 months from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on September 17th, 2025, officers of the Atlanta Police Department responded to a dispute call at 17 Brown Avenue, that's in Fulton County. When the officers got there, they spoke with I want to spell it. Savicia, yes, Seveicia Maddox, who stated that she got into an altercation with her brother. And what happened was she was helping her little sister, Janae Cummings, do her homework. And while she was helping her sister do homework, she would scold her or possibly got angry at her for questions that she got wrong. Because of this, the defendant in this case, they were in the same home. And when he heard Ms. Maddox talk to his sister this way, he walked out of the room and told her to stop yelling at her because she was getting stuff wrong on her homework. After that, the defendant went back into his room, and it happened again between Ms. Maddox and their little sister, where Ms. Maddox got upset that the little sister was not answering questions right for her homework. Because of that, at this time, Ms. Maddox reported to the police officers that the defendant came out of his room and grabs her arm to get her away from the little sister. At this time, the defendant placed his hands around Ms. Maddox's neck and began to choke her. She said that it was a point of time where she could not breathe. Eventually, he stopped choking her. She called the police and they responded to the scene. At this time, the defendant in this case was arrested for the charges we have before us. And those are the facts and circumstances of the case, with this case happening in Fulton County. Regarding the recommendation between the state and defense, we've agreed to 24 months for the defendant to serve 3 commuted to time served.
Say that one more time.
The recommendation?
Yeah, 24 months to serve 3?
Yes.
Okay.
To serve 3 commuted to time served, and that's for both counts 1 and 2. Separately, it'll be 12 months, but for them to run consecutive.
Okay.
So the total amount is 24 months to serve 3 commuted to time served.
Okay.
Regarding the special conditions of probation, we're just asking that the defendant complete a family violence intervention program and also to have no violent contact with the victim in this case.
Who is his sister?
Yes, Ms. Maddox. I did get a chance to speak with the victim in this case, and she kind of felt the same way she did when I called her about the bond hearing. She believes that her brother has learned from his mistake. She's not afraid to be around him. She wants him to be out so he can take care of his kids and his family. She wants him to get another opportunity. So she was okay with the reduction in this case and also for the commuted to time served because he has served some time in this case. But she did want me to give that statement to you since she could not be on the Zoom today.
Okay. So she is okay, one, having him out and about and plugged into his own family, but also that he could be around her. It's no violent contact with her.
That's correct.
Okay. Thank you. Ms. Harvey?
Yes, Your Honor. He has 1 prior adult cycle from 2022 for theft by receiving stolen property, and that case was dismissed, Your Honor. Nothing further.
Thank you.
You're welcome.
Ms. Wood?
Thank you, Judge. Mr. Alexander is 26 years old. He is an Atlanta resident. I did go ahead and fill out his contact information for the JCS intake form, and I sent that to Ms. Nelson. He is a high school graduate. He's currently enrolled at Atlanta Technical College. He's working on an HVAC certification. He does have 2 children, ages 2 and 1, and he shares them with his fiance. I spoke to her this morning. Everyone's just eager for him to put this behind him. So we would just ask that you accept the state's recommendation in this case.
All right. Mr. Alexander, how far along are you in getting your HVAC certification?
I just started school when I got home, sir, in March.
Okay, so you're fresh into the program. How long is it?
Yes, sir. It's about 6 months.
Okay. Are you working right now, or is class pretty much full time?
No, I work.
What do you do?
I'm basically like a bartender, but I make smoothies and stuff as well and food. So I work in a restaurant.
What restaurant?
It's called Boozy Smoothies.
Wow, where's Boozy Smoothies?
It's down in Atlanta, right here by Midtown train station.
Okay, we need them to do Fuda sometime. Okay.
Oh yeah, we cater. We definitely do cater. Call down here, search us up, and call down here.
I don't think we're allowed to have Boozy Smoothies down in the courthouse, though.
We make regular smoothies too.
Okay. Well, I'll keep that in mind. I'll keep that in mind. So do you and your fiance and your kids all live together?
Yes, sir.
Does your fiance work?
Yes, sir.
What does she do?
She basically like the police.
Well, I'm not sure what like the police means.
She work at the airport. She got a badge and everything, but like she don't like patrol and stuff.
Okay. Is she actually work for the Atlanta police, or she's a security guard, so she could not arrest you?
Yeah,
if you-
like a high class security guard, but they get guns and all that stuff like that.
Wow. Okay.
Yeah, you know what type of security I'm talking about?
Sure.
Okay.
Now to the even more important stuff. You and Ms. Maddox, you doing all right? Your sister, is she older than you or younger than you?
That's my younger sister.
Okay.
But yeah, we doing fine though. We done seen each other. Cause that's my actual like sister I grew up with. So I done seen her, when I came home. She came and visit. She came and see me.
Okay. And then Janae Cummings, is she a sister of yours also?
Yeah, that's the youngest. She the baby.
Okay. How many brothers and sisters do you have?
Not including me, I got 6.
Okay. Big family. All right. Do you have any questions about any of the things we discussed?
No, sir.
Okay. Well, Mr. Alexander, there is a factual basis for your plea to simple assault and to cruelty to children. The cruelty to children part, just so you know, doesn't mean you necessarily put your hands on Janae. It means she was there and had to witness what you and your sister were doing. So hopefully going forward, if you get upset with an adult, you don't do something in front of a little kid that's going to be traumatic for that little kid. But that's what the Family Violence Intervention Program is all about. I find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one forced you to enter the plea. Do you agree with that?
Yes, sir.
Okay. Do you mind, Mr. Alexander, if we electronically sign your name to the indictment indicating your guilty plea?
I don't mind.
Okay. Ms. Wood, do you mind?
No, Your Honor, thank you.
How about you, Ms. Smith?
No, Judge.
All right, we'll do that. No one minds. Mr. Alexander, I'm going to sentence you on count 1, the simple assault, to 12 months to serve 2 months with the balance probated. You've already served 2 months. You served 75 days is what it shows in the system. So 12 months to serve 2 months. And then count 2 would be 12 months. That'll run consecutive to count 1, but that'll be probated. So it's going to end up being 22 months on probation with the 2 months that you've already served, rounding us out at the 2 years. Special condition of probation number 1 is no violent contact with your sister, Savicia. Did I say that right?
Yes, sir.
Maddox. And special condition number 2 is that you're going to complete a family violence intervention program. That is actually a bunch of classes. It'll take a little while to complete it. I'm going to require you to enroll in it. In other words, get started within the first 4 months of your probation. Okay? So you got to start. You can start real soon if you want, but within the first 4 months, you must have started the family violence intervention program. Okay?
Yes, sir.
And probation can help you find one where you can enroll. Ms. Smith, anything else in Mr. Alexander's case?
Nothing further, thank you.
Ms. Wood?
No, Judge, thank you so much.
All right, so Mr. Alexander, last thing, Ms. Wood has filled out a form for you that's going to give your contact information to the people who run misdemeanor probation. They will be calling you, texting you, or emailing you, and maybe all of the above soon. Not today, but in the next few days. When they do, you need to make sure you respond because they're going to let me know if you don't. They're going to say this guy is not participating in probation, and that would be a bad report to get, okay?
Yes, sir.
All right. Anything else, Mr. Alexander?
No, sir.
All right. Good luck with everything.
Thank you.
Bye-bye.
Bye-bye.
Thank you, Judge. May I be excused?
Yes, go start your weekend.
Have a good one.
You too. Bye-bye. All right. Last but not least, we are back with Ms. Cabrera and Mr. Fagan. Ms. Cabrera, are we moving forward with his cases?
We are all 3.
Okay. Mr. Fagan, has managed to get mixed up in a bunch of things. He's got a gang case that Ms. Ocom is here for. And
I'm covering all 3.
You're going to cover all 3? Because I
Yes,
saw
it's
Ms.
a global plea, Honor.
Okay, you're gonna make it through? You sound like a wreck.
I do. I feel a wreck, but I will make it through, Your Honor.
Okay, all right. So does that mean Ms. Willingham can go or she needs to stay?
She can go, Your Honor.
Okay. Ms. Smith, you all done?
Yes, may I be excused?
As long as you think Ms. Ocam's gonna make it through, she sounds rough. Yes, you have a great weekend. No trial on Monday.
Yes, Judge.
Someday, although I'm running out of days
I
to
know.
do criminal trials. I don't know what it is. We can't get any of these murders to go. But that June 1st, something is happening. And we may just squeeze 2 trials into June.
Okay.
All right, let me shift paperwork here, and get Ms. Ocam on the screen. All right. Ms. Rivers, let's get on the record, please, with Mr. Fagan's 3 cases. He's got 24 SC 005178. That is the one with gang-related charges. He's got 26 SC 000125, terroristic threats and a few other charges. And then 26 SC 000126, another terroristic threats charge. Ms. Cabrera represents Mr. Fagan on all 3 cases. Ms. Ocam is going to handle things for the state on all 3 cases. Mr. Fagan, are you ready to go?
Yes, sir.
Mr. Fagan, I got to talk to you about 2 things before I hand it over to Ms. Ocam. Number 1, you have a right to be here in Fulton County in my courtroom to handle these pleas, but you can waive that right and we can go forward with you at Riverbend. Are you okay appearing virtually for your pleas?
Sir.
Number 2, you have a right to have Ms. Cabrera right there with you. I don't know that she wants to go to Riverbend, but in theory, you've got the right to have your lawyer next to you so you could just lean over and ask a question. Ms. Cabrera is not there. She is in some other county where she does lots of legal work. Are you okay, Mr. Fagan, that Ms. Cabrera is also appearing virtually?
Yes, sir.
Will you let me know if you need to speak with her privately at any point?
Yes, sir.
Will you also let me know if at any point you've got questions about things or you can't hear us because the connection's not working?
Yes, sir.
Great, then we are ready to move forward. Ms. Ocam's going to put you under oath, ask you about your cases and your rights, and we'll take it from there.
Okay.
Mr. Fagan, do you solemnly swear that the testimony you're about to give will be the truth and nothing but the truth to help you God?
Yes, ma'am.
Would you please state your name and your age and your date of birth? Please spell your full name, please.
Shad Fagan, Rashad. Fagan is spelled Fagan. And date of birth is December 20th, 2000.
And how old are you?
25 years of age.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
You can put your hand down, Mr. Fagan.
I'm sorry, you can put your hand down, Mr. Fagan. Is there any medicine that you should have that you have been prescribed that you're not taking right now?
No, ma'am.
Okay. How far did you go in school?
11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're pleading guilty today to 3 different cases? You're pleading guilty to in case indictment number 24 SC 005178, you're pleading guilty to 1 count of criminal gang activity and 1 count of theft by taking. Do you understand that, sir? Is that a yes?
Yes, ma'am.
Okay. As to case number 26 SC 00125, you're pleading guilty to 1 count of terroristic threats and 1 count of resisting law enforcement and 1 count of possession of a firearm by a convicted felon. And as to the last case, 26 000126, you're pleading guilty to 1 count of terroristic threats. Do you understand that, sir?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you in all 3 cases, sir?
Yes, ma'am.
By pleading guilty today, do you understand that you're giving up the following rights? You're giving up the right to trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney assist you throughout the trial proceedings, and the right not to incriminate yourself. Do you understand that?
Ma'am.
Do you understand that if you were to plead not guilty or to remain silent and to enter no plea at all, the state would be required to prove all these charges at trial by jury? Do you understand that?
Yes, ma'am.
Do you understand as to case 25, I apologize, 24 SC 005178, as to counts 1 and 2, participation in criminal street gang activity, the maximum sentence is 20 years. As to count 3, theft by taking, the maximum sentence is 10 years. Do you understand that, sir?
Yes, ma'am.
As to case number 26 SC 000125, as to 36 threats, count 1, the maximum sentence is 10 years. As to count 2, possession of tools for a crime, the maximum sentence is 5 years. As to count 3, willful obstruction of a law enforcement officer, misdemeanor, the maximum sentence is 12 months. As to count 4, as to count 4, reckless conduct, the maximum sentence is 12 months. And as to count 5, possession of a firearm by a convicted felon, the maximum sentence is 5 years consecutive to the predicate counts. Do you understand that, sir?
Ma'am.
As to case number 26 SC 000126, for the lone count of terroristic threats, you understand that the maximum sentence in that case is 10 years as well.
Yes, ma'am.
You are currently serving a sentence, is that correct, sir?
Yes, ma'am.
And for purposes of this plea, do you understand that as to the plea negotiated between the state and your and you, is that as to the gang case 24 SC 005178, the sentence recommended is 15 years to serve 14 months, with your release dates being February 14 of 2027, which is concurrent to the current case you're serving. As to count 2, that will be null pros for purposes of the plea. As to count 3, theft by taking, it would also be 15 years to serve the 14 months concurrent to each other. As to case number 26 SC 000125, the state is recommending a sentence as to count 1, terroristic threats, 10 years to serve 14 months with the same release date. Counts 2 and 3 and 4 will be null pros for purposes of the plea. Count 5, possession of a firearm by a convicted felon, will be 5 years on probation consecutive to count 1 in that case, but concurrent to 24 SC 005178. As to case number 26 SC 000126, the state's recommended sentence is 10 years to serve 14 months concurrent to your prior case. So your total sentence will be 15 years to serve 14 months, balanced on probation. There are specific conditions of your probation. You understand that you should have no gang paraphernalia in your person and or on social media. You should have no weapons, real or replica, on your person and or on social media. You're to stay away from the incident location. You're also to stay away from the victims in this case. No contact with Shaquandra Alford. Spelling of Shaquandra is SHAQUANDRA. You have to stay away from Nigeria Alford, NYKERIA. Excuse me, Alford, common spelling. You're also to stay away from Mr. Jami Williams, common spelling for Williams. Jami is JAHMI. Stay away from Jawara Headley. Spelling for Jawara is JAWARA. Headley is HEADLEY. And you're not to return to the incident location, which is 3293 Seville Street. You're also to undergo the Family Violence Intervention Program. any mental health evaluations, and follow any recommended treatments by probation. Do you understand that, sir?
Yes, ma'am.
Do you understand that the court is not required to follow that recommendation, but can sentence you to up to the maximum sentence permitted by law, which I have previously stated to you? Do you understand that?
Yes, ma'am.
Since this sentence includes probation, you understand you're supposed to, you have to follow general conditions of probation as well as the special conditions that I have listed out to you today. Do you understand that?
Yes, ma'am.
Do you understand any violation of the special conditions of your case could lead to revocation of your probation? Do you understand that, sir?
Yes, ma'am.
Are you entering your guilty plea with an understanding of everything we have just talked about?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything that will cause you to plead guilty against your will today?
No, ma'am.
Are you satisfied with your lawyer, Ms. Cabrera's work that she has done for you in this case?
Ma'am.
Do you have any more questions that you would like to talk to her about before we proceed?
No, ma'am.
Have you understand everything that I have asked you today?
Yes, ma'am.
Ms. Cabrera, are you confident that your client understands everything that we have talked about today and is entering this plea voluntarily and to his own free will?
Yes, ma'am.
Do you waive formal reading of the indictment for purposes of the plea?
So waived.
Do you waive any errors in the indictment, including with respect to your client's name for purposes of the plea today?
Also waived.
Understanding your rights, sir, do you wish to enter a guilty plea on these charges today, Mr. Richard?
Yes, ma'am.
As to, is your decision to plead guilty today made freely and voluntarily today?
Yes, ma'am.
Are you a United States citizen, sir?
Yes, ma'am.
You understand that if you're not a United States citizen, your guilty pleas today will affect your United States citizenship and may result in your deportation if you're not a United States citizen.
Yes, ma'am.
Do you understand that as you are pleading to felonies today, you have 4 years from today to file a habeas corpus petition to challenge the voluntariness of your plea? Do you understand that, sir?
Yes, ma'am.
Do you understand that also that you have 30 days from today or from the term of court, whichever is longer, to file a motion to see if the court, a discretionary motion to see if the court will grant you the ability to withdraw your guilty plea? Do you understand that, sir?
Yes, ma'am.
Following all this, is it still your wish to plead guilty to today?
Yes, ma'am.
How do you plead as to counts 1, participation in criminal sea gang activity, and count 3, theft by taking in case number 24 SC 005178? How do you plead?
Guilty.
As to counts 1 and 4, terroristic threats and possession of a firearm by a convicted felon in case number 26 SC 000125. How do you plead?
Guilty.
And as to the lone count, terroristic threats in case number 26 SC 000126, how do you plead?
Guilty.
Your Honor, that concludes the state's colloquy. I can go through the facts of the case now if you would like.
I'm ready. You can give me a high-level summary of each.
Thank you, Your Honor. As to case number, I'm sorry, I apologize.
You can just use the last 3 digits on them. I think we'll be able to follow along. So we've got 178, 125, and 126.
As to 126, Your Honor, if this had proceeded to trial, the state would have proved on or about October 12, 2025, Officer Henry encountered 2 females who came to the precinct who stated that the 2 females were Miss Nigeria Alford. She said that she had received text messages from her child's father, which is the defendant, that he said he was going to kill her because Miss Alford said she would not let him see the child that they share together, Your Honor. As to case number ending in, I apologize, it's the other terroristic threats. Case number ending in 125. The state If that had gone to trial, the state would prove beyond a reasonable doubt that on or about December 24th of 2025, officers were dispatched to 207 Richardson Street Southwest, where they met with the victims who said that the defendant had threatened to shoot him and the location up. Officers were advised that the defendant was walking in the nearby park. When they got there, they detained Mr. Fagan. Upon detaining him, they found on his person a ski mask as well as a loaded gun, a 9mm Glock, in the area where they had found the defendant, where Mr. Fagan had discarded the firearm. As to the gang case ending in .178, if that had proceeded to trial, officers, the state would have proved beyond a reasonable doubt that on or about January 23rd of, between the days of January 21 and 23rd of 2019, officers were dispatched to several locations about vehicles that had been broken into. This case was not broken until January 20 of 2023 when GBI recovered the defendant's DNA matched blood from the vehicle break-ins on the scene. At that time, the gang unit was also investigating the defendant. The defendant is a known member of BN5, which is Breaking News 5. That gang is well known for breaking into automobiles and vehicles, entering autos, hijackings, and fleeing. The defendant is a long member and has tattoos stating of his allegiance to the gang. At that time, Long Live Ralph, which is tattooed on his neck with a green stake, which is all what fellow members of the BN5 showed their allegiance to. It was a group of them that had broken into cars over that period, Your Honor, 21 and 23. There were multiple break-ins, and he was later identified after his DNA came back, Your Honor. Concludes the state call. Excuse me. Thank you.
You're welcome. You did it. Nice work. You're almost done. And you can go to the emergency room. So Ms. Harvey, our last case of the day, 3 cases, 1 defendant. Can you share criminal history on Mr. Fagan?
Yes, Your Honor. He had 17 cycles. He did receive first offender in 2020 for terroristic threats. That case was discharged in 2025. There's a 2020 conviction for possession of tools for commission of a crime and theft by receiving stolen property. Also, 2020, 2 counts of financial transaction card theft and 2 counts of entering auto. 2021, entering auto, 2 counts of aggravated assault, 2 counts of possession of a firearm during the commission of a felony, and 5 counts of unlawful for a person employed by a criminal street gang to participate in criminal activity, and a 2024 conviction for 2 counts of fleeing or attempting to elude a police officer out of Cobb County. And nothing further, Your Honor.
Thank you. Ms. Cabrera.
Yes, Judge, I'll keep it short. He's 25 years old. He hasn't completed high school, but he is working on his GED while in custody now. He does have 1 child, age 6, young lady. He has, to my understanding, although his sentence is up, his current sentence is up in February of 2027, he does have holds that he needs to respond to in Cobb and Clayton County. To follow this, I'm asking that Your Honor accept the plea as negotiated, and that he be allowed to go on ahead and have this case run concurrent with the sentence he is currently serving now.
And that's where the 14 months factors in, because he should be getting out. I mean, he gets credit for some of the time he's been in since arrest, et cetera. But then 14 months should make it kind of coterminous when he gets out.
Yes. Yes.
Okay.
That's the plan.
That's the plan, yes, Your Honor.
Okay. Mr. Fagan, why are you at GDC now? Did you get revoked on something, or you got a bunch of convictions? I'm just trying to figure out which thing landed you in the Department of Corrections. It's a probation violation. Okay.
You are right.
Okay. All right. Mr. Fagan, your daughter is staying with whom?
It's Alfred, not Carrie.
Oh, that's her. Oh, got it. The person you had the situation with last October. That's her mom, and so that's who she's staying with. Okay. All right. Do you have questions about anything we discussed?
No, sir.
All right. Well, Mr. Fagan, I find there's a factual basis for your pleas in these three cases. The stolen Impala is a real old case. That's 7 years ago, but it was a COVID delayed indictment, and that one I'm impressed it's still hanging on. The other two are kind of recent. It was Christmas Eve of last year, and then the middle of October of last year. When you get out, do you gonna go stay with Ms. Alford, or do you stay somewhere else?
I stay somewhere else.
And where is that? I don't mean like what's the street address, but who do you stay with?
My mother.
Okay. And what city does she live in?
She was recently staying in Clayton County. She just moved recently though. So I don't know. I've been in custody in prison and my phone hasn't been approved, so I haven't been able to talk to her really.
Got it. So she's in a new spot.
Yes.
How long have you been in prison?
About going on 6 months now.
Okay. You get revoked for what, 20 months, or how long did you get revoked?
14 months.
Oh, for 14 months. What is the credit for time served date, Ms. Cabrera, that you think we're using here?
February 16th of 2027. I apologize, Your Honor.
Oh, okay. You may have said that before. All right. So credit for time served from February 16th of 20. No, that's the.
Oh, no, I'm
release
sorry.
date.
That's the release date, Your Honor. I could tell you what the.
Yeah, I can't give the Department of Corrections a release date. I can give them a start date.
I think it's 12/24/2025.
Oh, that would make sense. He has to have been out on that day. Okay.
Yeah.
24 December 25. All right. Mr. Fagan, like I said, I'm accepting your pleas. There's a factual basis for each. I also find that your pleas are knowing and voluntary. You've done this before. You understand how pleas work. You have a lawyer who has counseled you well. Ms. Ockham, can someone in my office sign all three indictments so we don't have to go anywhere near you?
Yes, Your Honor.
Good. All right. Ms. Cabrera, can we sign for you?
You can.
All right. Mr. Fagan, you all right with electronic signatures on your three indictments?
Yes, sir.
We'll do that. On 24 SC 005178, count 1, 15 years to serve, 14 months, balance probated. That is a mountain of probation. I don't normally like having probation for that long, but you've racked up so many cases. I think it makes sense. If you're ready to turn a corner, do something different, fantastic. If you're not, then we can just reel you back in with this revocation. Count 2, the state is dismissing. Count 3 would be 10 years to serve 14 months, balance probated. Those counts will run concurrently with each other. Special condition number 1, get your GED. If you do that before you get out, you're ahead of the game. And special condition number 2, when you do get out, you'll submit to a mental health evaluation. And if that doctor recommends any treatment, whether it's counseling or medication or whatnot, that treatment is part of your sentence. In 26 SC 000125, your sentence on count 1 is 10 years to serve 14 months with the balance probated. Counts 2 and 3, the state is dismissing. Count 4 is 5 years. It doesn't have to, but it will run consecutive to count 1. So that gets us to the same sentence as your other case, 15 years to serve 14 months with the balance on probation. Special condition in that case, get your GED. And finally, in 26 SC 000126, just one count, terroristic threats. Your sentence is 10 years to serve 14 months, balance probated. Here, special conditions, get your GED. Also, Within 3 months of your release, you need to enroll in and begin your work on the Family Violence Intervention Program. That is a bunch of classes. You don't knock it out in one session, but you need to start within the first 3 months of probation and no violent contact with Ms. Alford, the mother of your daughter. What's your daughter's name?
Yeah.
All right. Ms. Cabrera, anything else in connection with your good work on behalf of Mr. Fagan?
Nothing further, Judge.
All right. Ms. Ocon, get any
Yes,
last
Your
words
Honor.
at? Yes.
Yes, you forgot the gang conditions.
Oh, right. In the case ending in 178, there are additional conditions where you will not associate with known gang members. So if you're around some guys who you know were part of Breaking News 5 or a part of the Bloods or the Crips or whatever, you cannot be around them. If your probation officer sees social media of you hanging out with guys and they're doing signs or you're dressed a certain way, people cannot help themselves but post those images. And your probation officer is going to be looking, and if they present them to Ms. Ocom, she will have recovered from the ick, and she's going to say, we need to revoke your probation. And I will, because you need to not hang with that crew. And what I don't remember, are there other standard gang conditions?
Yes, Your Honor, the weapons real or replica in person and or social media.
Okay, so nothing on social media that advocates for or promotes gang activity. And then no replica weapons. You can't have one anyway because you are a felon several times over. But sometimes people will be in these photos and they'll say, oh, that wasn't a real gun. If it looks like a gun, that counts for your probation, and that'll be a problem for you. So keep it boring when you get out. Take care of your daughter, take care of her mom, head in some other direction, and be done wearing that white outfit. Doesn't look good on you anyway. You should be doing other stuff. So I think we're done, except Ms. Nelson has a question. I need to make sure I answer it before people go. Oh, Ms. Ocom, if you could, as one of the last things you do before you crawl back into bed, email Ms. Nelson the special gang conditions. Cut and paste, whatever's easiest for you. She's not confident that I've adequately pronounced them. And she just wants to word them right so that Mr. Fagan doesn't trip up. It'll be real clear if you send those to her. Okay?
Yes, Your Honor.
All right, hold on. One more thing. Ms. Simpson? Sure. 125. Oh, I may have skipped over. There's three. The counts 2, 3, and 4 are dismissed. I may have treated it as only 2. So count 1, 10 served 14 months, balance probated. 2, 3, 4 dismissed. So it's a gun count, obstruction, and reckless conduct. But count 5, which I may have called count 4 mistakenly, which is possession of a firearm by a convicted felon, that is 5 years consecutive, getting us to the 15 to serve 14 months. Is that better? Okay. All right, Mr. Fagan, any questions?
No, sir.
All right. Well, thank you, Riverbend, for making Mr. Fagan available. You guys have a great weekend.
Thank you. You too. Thank you.
All right. Bye-bye. All right, Ms. Ocom, go lie down.
Thank you, Your Honor.
Yeah. See ya.
Have a good one, Judge.
Bye, Ms. Cabrera.
All right.
Ms. Harvey, thank you so much for your help today and jumping in at just the right time in each place. Ms. Rivers, thanks for all the takedown. You guys have a great weekend. We'll be here for another hour and 45 minutes presiding if anyone wants to come by with presiding matters.
Okay, Judge. Have a great weekend.
All right, bye-bye.